Welcome. We're on the record for the hearing in the matter of the application of Snake River Oil and Gas LLC for an order integrating unleased mineral interest owners in the spacing unit consisting of the southeast quarter of Section 15, the east 1/2 of the southwest quarter of Section 15, and the northeast quarter of Section 22, Township 8 North, Range 5 West, Payette County, Idaho. This is a proceeding before the Idaho Department of Lands. It's agency case number CC-2025-OGR-01-005, and its Office of Administrative Hearings case number 25-320-OG-04. I am the assigned hearing officer for the case. My name is Scott Zanzig. As I mentioned earlier, I'm with the Office of Administrative Hearings in the state of Idaho. This is a proceeding where we will have an evidentiary portion where the parties to this case will present evidence. We will then, at the conclusion of that evidentiary portion of the case, have an opportunity for any members of the public who are not parties to the proceeding to be able to speak if they would like to. When the witnesses testify in the evidentiary portion of the case, they will testify under oath. People who provide public comment after the evidentiary portion are not required to testify under oath. They're allowed to make whatever comments they would like to make. So to get started, I would like all the parties in the case have legal counsel. I would like counsel to introduce themselves and their parties, beginning with the applicant, then with the objectors, and then finally the Department of Lands.
Michael Christian for the applicant, Snake River Oil and Gas.
Thank you.
James Piotrowski here on behalf of Julie Fugate, Darlene Walker, Sharon Harmon, Doris Craig, Larry Morris, Charlene Gomez, and John Sandquist, all in their roles as property owners or trust, either directly or in trust. I'm also appearing as counsel for Kaya, which has been denied status as a party and so is not appearing at the hearing per se.
Thank you, Mr. Piotrowski.
Haley Richter, I am in the General Counsel's office at the Idaho Department of Lands, and I'm here with James Thumb, the Idaho Department of Lands Oil and Gas Program Manager.
Thank you. So the way we will proceed with the evidentiary portion of this hearing today is first the applicant, Snake River Oil and Gas, will be allowed to put on its evidence. After it rests its case, then Mr. Piotrowski will be able to put on any evidence on behalf of the objectors he would like. And then finally, we'll have the Department of Lands put on any evidence it would like. Following that, Snake River Oil and Gas will have an opportunity to present any rebuttal evidence it wants to address things it might have heard from the other parties. It gets that opportunity because it has the burden of proof in this case to establish that it is entitled to the relief that's requested here. So, Mr. Christian, let's start with you. Any party who wants to is entitled to make brief opening remarks if they would like to. Otherwise, you're free to just call your first witness. And when we have a witness come to testify, I'd like the witness to sit right up here in front because then everyone can see him and the camera will be able to see him as well.
Thank you, Mr. Zanzig. As a preliminary matter, the parties had not previously discussed stipulating two exhibits. I had some preliminary conversations with counsel in the room before this, and I understand based on those conversations that the parties will stipulate to the admission of the applicant's exhibits SR01 through SR06. I'd like to confirm that and move their admission if that's the case.
Okay, Mr. Piotrowski, any objection?
We have no objection to the exhibits.
Thank you. Ms. Richter?
No objection.
Okay, so the applicant's exhibits SR01 through SR06 are all admitted and they're part of the record. I also have in my file, while we're at this, two exhibits from the Department of Lands, IDL-01 and IDL-02. Mr. Christian, any objection to admitting those documents?
None, sir.
Mr. Piotrowski? Thank you. So the Department of Lands Exhibits 1 and 2 are admitted and they're part of the record as well. Any other preliminary matters, Mr. Christian?
No, I'm prepared to offer a brief opening statement and then I'll call my first witness.
Okay, before you do that, let me just ask, Mr. Pietrowski, do you have any preliminary matters you want to take up?
None.
Thank you. And Ms. Richter?
No, thank you.
Okay, so you may proceed.
Thank you, Mr. Hearing Officer. As is set forth in our application materials, which for the record are at Exhibit SR-01 and in the additional exhibits that we have filed, we submit that the applicant has met the requirements of Idaho Code 47-320 and Idaho Code 47-328 for obtaining an order integrating mineral interest in the subject spacing unit. Broadly, A, on the basis that they have leased over 55% of the net mineral acres in the spacing unit. B, they have made the required 2 contacts within 60 days of filing the application and have engaged in diligent and good faith negotiations in this spacing unit for well over the 120 days required for integration at above the 5% level. In fact, for a number of years before they filed the application. C, they have made all the required certified mailings and publications of notice to uncommitted owners, both before and after filing the application. D, they have established through the declarations of Richard Brown and Wade Moore that a 1/8 royalty and $150 per acre bonus are appropriate for the base entitlement under Idaho Code 47-320, although there are a couple of questions that the department raised in its pre-hearing statement that I will address through witness testimony. And I will note that those terms have already been approved in previous integration hearings in this area. And E, we've established through Mr. Brown's declaration that a form of joint operating agreement that's been offered as appropriate is used by the applicant with its own working interest partners, and that form has been approved again in other integration proceedings. We would respectfully submit that the entitlement to an integration order is established by the application materials on file and that have been admitted now, but we will provide the testimony of Mr. Brown and Wade Moore to answer some of the questions the department raised. And at the conclusion of the hearing, we will request that you recommend the issuance of an integration order on the terms requested in the application.
Thank you. You may call your first witness.
I call Richard Brown.
Middle one, before, right here, please. Yeah, thank you. Mr. Brown, before you testify, you need to take an oath, just like you would in a court of law. Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. So you proceed.
Thank you. Richard, can you state your full name for the record, please?
Richard Wesley Brown.
And you are a member of the applicant Snake River Oil and Gas?
Yes, I am.
Okay. You provided the declaration as part of the application materials in this matter. And just as a preliminary matter, let me finish asking my question before you answer, and I'll try not to cut you off. And if I ask you yes, no questions, say yes or no, or it's sometimes hard to translate or transcribe. With that, can you give me a brief description of your education and professional background?
Yes. I'm a petroleum landman with a degree from the University of Texas in Austin in petroleum land management. I've been practicing in that field. I'm 66 years old and been practicing since I was 22 when I graduated from university.
And I take it you have practiced your profession in states other than Idaho?
Yes, I have.
What states have you worked in?
Texas, Louisiana, Arkansas, Oklahoma, Idaho, a little bit in Mississippi, a little bit in Alabama.
And how long have you been involved with the applicant Snake River Oil and Gas?
Since its inception in, I believe, 2010.
And Snake River Oil and Gas has been working in this basin since that time,
Yes,
taking leases and drilling and operating wells.
yes.
About how many operating wells does Snake River have now?
I believe we have 10 producers or 11.
Okay. You have provided the declaration in this matter. Have you reviewed it before the vote hearing?
Yes, I have.
Is there anything in it that you wish to change?
There was one item, it was a statement about a meeting with HOA. It said that we met in 2024 and that meeting actually happened in 2023. And there was a statement, we actually started leasing in this area. I think it said 22, but we actually started, we bought the first leases in 2016, but we aggressively started leasing in 2020 and then we started buying an additional acreage when we added an additional 80 acres to comprise a 400-acre unit. We started that in, I believe, in 23.
And were you engaged with or responsible for supervising the landmen working in the spacing in the area to acquire leases?
Yes.
And about how often would you meet with your land team?
Every 7 to 14 days, we would have a team meeting.
Okay. There were a couple of questions that were raised in the department's pre-hearing statement. One was the question about whether any lessor in the unit had been paid more than $150 per acre as a lease bonus. Has Snake River paid any lessor in the unit more than $150 an acre lease bonus?
No.
The second question was how tracts of less than an acre are treated. The question was whether in acquiring leases for small tracts under an acre, you have paid a flat rate, like $150, or whether you've paid a pro rata amount based on the size of the tract. Can you answer that question?
I think some of both, but I'll defer to Wade, who will also testify. But I think we paid some on a pro rata, and then I think we paid some a flat fee of $150 per lot.
In your declaration, there was a discussion of the form of JOA that was joint operating agreement that was included as part of the application materials. You recall that?
Yes, I do.
You made some statements about why it's appropriate. Is the JOA form that's been supplied, first of all, has it been approved for use in other units in this area?
Yes, it has.
And is it the same form essentially that you use with your working interest partners?
Yes, it is.
With the exception that the risk penalty in it is actually lower than that you use with your working interest partners.
Correct.
Is that form the same form that you use in other jurisdictions?
Yes, it is.
Okay. I think that's all I have for you, sir.
Thank you. Mr. Piotrowski, any cross-examination?
Yes. Good morning, Mr. Brown. Is there any basis to your knowledge to believe that in operating this well, you would have any reason to occupy the surface of any of the non-leased properties that you're proposing to integrate?
And will you ask that question?
Absolutely. Is there, as you sit here today, is there any reason to believe that if you become the operator for this well and you complete it, that you will have any reason to use the surface of the properties owned by the non-leased owners?
Let me make sure that I'm clear with your question. You're asking if we would need to use the surface, any of the parties that are to be integrated?
Correct.
Okay, the answer is no.
Okay, so so SROG can complete its work without having any right or entitlement to use the surface property of anybody except those who have a lease with you, right?
Correct.
Okay, and so no surface occupation is a term that would not interfere with your operation of the well.
In regard to integrating parties, correct.
Okay. Now, I don't quite understand the geography of this particular unit, but maybe you can answer this. The properties, you've chosen a well site, right?
I'm sorry?
You've chosen a well site?
We have a tract, yes.
Right, yeah, which you needed to do in order to make your application, right? You had to lease the location where you're gonna put the well.
Correct.
Okay, and the properties, how large is that tract that you've leased for placing the well?
I believe it's 18 acres.
Okay.
And I stand corrected, but I believe it's 18 acres.
Do you recall which of, I'm gonna do this in a really horrible way, but I don't suppose you remember which lot number it is on your maps where you're putting the well?
I do not, if you can
Oh.
put the.
And I'm asking because I'm looking at I know I can find the information, look at the exhibits for today and I don't see the well site marked on the map. You see, did we put that on the Zoom? 1 second. That exhibit SR6.
It's just a picture.
Okay, so the exhibit we've got for the hearing today breaks this unit down into smaller chunks so that we can actually see what's going on there. Do you know which?
Right.
Do you know which of these is the well site? And there are several more pages of this map if you need me to scroll down.
Get closer to the screen. Wait, is that?
Yes, you may.
Wait, am I correct? It's 62?
62, thank you.
Is that correct?
Do you believe that to be correct?
I do.
Okay.
Yeah, because it's.
Somebody will correct
Yes,
it if we're wrong.
yes.
Right. And so to the right of 62 is an unshaded portion. Is that outside the spacing unit?
No, it is not.
Okay, so this shaded portion, bottom right part of this is on the second page of this. Could you scroll to the second, to 06 B or A2? Okay, so that's what exists next to that I was just asking about in the previous map, right?
Correct.
Okay, and a number of these properties are unleased, right?
Correct.
And they would be integrated if this application is granted, correct?
Correct.
And to what extent are you going to end up drilling underneath those properties or underneath any other integrated property?
I'm sorry?
To what extent, when you go to drill the well, to what extent will the well bore pass under the properties of integrated owners?
To what extent?
Yeah,
I believe there will be one party that the wellbore would go beneath. None of these parties.
Okay, let's go back up to the first page. Exhibit A, yeah. So are you able to identify on this map which of the parties might have the wellbore under their property? You can look closer if you need to.
The only party would be, I believe, 105.
Okay. Other than 105, you don't believe any other non-leased property would have the wellbore anywhere within, over, or under its property?
Correct.
Okay. And would a term on this integration order that provides that the operator shall not occupy the subsurface property rights anywhere but lot 105, that would not interfere with your operation of this well, right?
As it's I'd have to consult with our, ask your question again, and I think I can answer it in the affirmative.
Other than what's identified on exhibit SR06 as tract 105, other than that, are there any other integrated acres under which the wellbore would pass?
No.
Okay. And so a condition that there will be no subsurface occupation, perhaps other than in number 105, would not in any way interfere with Snake River Oil and Gas's operation of this well.
Let me look at something.
Sure.
So to get the gas out, we have to come south. And then when you define subsurface, we would find a bore, come down to, I think that's, is that 16th? Is that right, Wade? 16th? So we would take a path, there's a road or a four-wheeler road or a little ditch road right here. We bore from there. So when you say subsurface, we've got to have ability to get the gas out. We would bury at minimum of 48 or say 40 inches. So we have to provide for the ability to get the gas out. So when you say subsurface, well, go ahead and ask your question again.
Sure. Let's break it up a little bit. In terms of the well bore only,
Correct.
is it correct that the only non-leased property that well bore may end up underlying is number 105?
Correct.
Okay. Where, assuming the well produces, in what direction will you need to move that gas to get it to market?
We're planning on coming due south.
And will you do that within the limits of what's indicated there on SR06 as tract 62? Or will you instead follow the unleased road that you said is at 110?
Yeah. I would. I'm gonna say I'd rather Wade is much more familiar, so we can ask this question to Mr. Moore. He's much more familiar with the tracks in there and it narrows, but that's the intention. So everybody understands what the intention is the well bore to come down under what did I say, what was it, 106?
62 to, and then the well bore, it seemed would be angled at least to some extent towards the west.
Yes, and
And would
that's
end up under 105.
105.
Okay. And the target point would be under 105?
Correct.
Okay. And as subsurface, I can probably get better information from Mr. Moore, you're saying, is that right? As to pipeline for moving the product, that would come from Mr. Moore?
Correct.
Thank you. The current drilling plan, the application indicates, of course, that this is all somewhat experimental. Does the current drilling plan include any hydraulic fracturing?
No, it does not.
And your permits to date allow only the drilling of one well, right? I'm sorry, terrible question. Let me withdraw that, please. In the spacing decision, when the spacing unit was established, it was established and limited to the drilling operation of one well, right?
I do not recall. I don't recall what the spacing order said.
Okay. And do you have, does SROG, Snake River Oil and Gas, have any current plans for more than one well?
Currently, no.
And an additional well, okay, thank you very much. Do you have a well permit for that location yet?
I'm sorry.
Do you have a well permit for that location?
No.
Okay. You've been working on this particular, well, in this particular area, and what eventually became this spacing unit, you said since about 2016?
The first lease was bought in 2016.
Okay. And at this point, you've got over 55%, you're seeking an integration order, and what would be the intended start date for drilling?
Hopefully, spring of 26.
Okay. And do you recall the intended, do you have an estimate of how long it will take to complete the well to its bottom point and determine whether it can produce?
Let's see the last part of that question.
To complete the well to its target point and determine whether it will produce or not.
7 to 12 days.
Okay. So is it fair to say then that by next summer, which would be June 22 or so, you will know whether this well is going to be producing or not?
I would hope.
And you fully expect it to produce, right? You wouldn't be doing this otherwise?
Would hope so.
Okay. So a lease term with a shorter term, for instance, 3 years, which is often used for mineral leases, a term of 3 years would be more than adequate to allow Snake River Oil and Gas to bore its well, drill its well, whatever the term is, and determine whether there will or will not be production from this well, correct?
It would be quite a bit different than what the other leases in the unit were. So if the objective is to give the integrated parties comparable lease, that would vary quite a bit from.
But if the purpose was different, if it wasn't just about giving a comparable lease, a shorter lease term, a 3-year lease term with no renewal, would allow you to get the job done in this case, wouldn't it?
Possibly.
Assuming that the hearing officer is official, which he will be, we're going to have a decision on this in fairly short order, and certainly within the period from 3 years from now. Is there any reason to think that a 3-year term on those leases would interfere with your operations?
I sure hope not.
Okay. How much bonding do you understand that Snake River Oil and Gas is prepared to provide to cover the property environment so that we get integrated?
Sorry, did you say
Bonding.
bonding, BOND,
Correct.
Angie? We're mandated by the state to, per the state statutes, and I can't remember the exact amounts, but they're higher in Idaho than I think in any other state that we operate.
Does $6,000 sound familiar?
That does not sound familiar.
How much do you think is the bonding you would purchase on this project if SROG is operating?
It's well over, I would have to consult with our operations manager, but it's significant. Very, very significant.
But you don't have an estimated dollar figure you can put on it?
I I didn't prepare for that when I walked in here, but I can get it. It would be the same bonding that we have for all the other wells.
That's not mine.
Yes. Oh, I don't have that ringtone, but it would be the same bonding that's required in all the, I believe, all the other units that we operate. It's a uniform.
Have you, I know you're not the designated operator yet, but have you made any efforts to, has SROG made any efforts at this point to meet with either, discuss with either the county or city of Fruitland about operations traffic, where you will be moving your traffic to move equipment for the drill?
We've had informal meetings with them, yes.
And what's the current traffic plan? If there is one.
I would have to defer to Mr. Moore.
So I didn't quite understand the testimony you provided, and maybe you're not the best witness for this, which might be why that is so. But do you understand that there were some owners whose tracts were less than 1 acre, but who nonetheless received a $150 bonus payment for their lease?
I believe there were some lots, some small lots, owners. Mr. Moore can answer, but I believe there were some lot owners that received $150.
Even though their lot was less than 1 acre?
Correct.
Okay, and you understand that in your application, SROG is requesting $150 per net acre, is that correct?
That is correct.
And that would actually result in somebody with less than 1 acre getting less than some of those leaseholders got. Is that right?
That is correct.
Okay. Thank you. That's all the questions I have.
Ms. Richter, any cross-examination?
We have a moment to
Yes.
double check. Thank you.
Thank you. Any redirect, Mr. Christian? Briefly.
Mr. Brown, Mr. Pietrowski asked you questions about the path of the wellbore and where the wellbore bottom hole may end up. All those questions?
I do.
And you identified track 105. It's true though, isn't it, that the wellbore would have to pass under the railroad?
Very good point. Yes, yes, and
And the railroad,
it's a different tract?
the railroad is all 110.
I'm sorry?
I think the railroad is all 110. But
Okay.
that also reflected in the other.
Very good point. Thank you.
Is it, I'll let you sit down. The well has not been finally designed, is that right?
That is correct.
Is it possible that there may be some variability? You're generally gonna drill directionally to the southwest, but there may be some variability in where your target ends up.
Yes,
So is it possible, for example, that you could end up on parcel 106 further to the south, just to the south of 105?
yes,
Okay. But generally speaking, that's the planned path.
correct. And we would definitely, so I stand corrected. We would definitely have to cross, is that one, I can't see it, 110 is the railroad?
The railroad.
Okay, yes, we absolutely would have to cross under 110 to get to 105 or 106 if we stretched into 106.
Okay. On the subject of getting the product out of the unit, you answered Mr. Piotrowski's question and said that the intent is for you to go essentially due south, perhaps on that part of 110, but to get to 16th Street, is that right?
Correct.
If you were not able to do that for some reason, couldn't get rights of way from the county or something like that, which direction would you have to go to get out?
Some direction, I mean, would be an alternate path. And as I mentioned, we plan to bore, but go ahead.
Okay. Let's say you were to go to the east, here's a broad question. When you're boring and installing your flow line to get the product out, you go down the middle of the track, you try to stay on the property boundary?
Almost always stay on the property boundary because it's least invasive for everybody.
Okay. Is your route to the south, is it finally established? Like, do you have permits in hand?
No.
Okay, so there's at least a possibility you may have to find an alternate route.
Yes.
Okay. Other than running a flow line to get product from the well out, do you foresee any other subsurface occupancy needs?
I do not.
And would your flow line carry liquid and gas together?
Yes.
I don't remember the question, excuse me. Oh, you answered some questions for Mr. Piotrowski about bonding. Does Snake River hold a blanket bond or individual well bonds? If you don't remember that.
I don't recall. We have insurance and we have bonding, and better stop there.
Okay.
It's extensive. That's what I can tell you.
Has Snake River had other integrated units in the past where there has been provision made for what I'll call town lots less than an acre to receive a flat, whether it's $100 or $150, whatever was the rate at the time? Have there been other units where there's been provision for a flat rate for sub 1 acre lots?
I believe so.
That's all the questions I have.
Thank you. Any recross, Mr. Piotrowski?
None.
Thank you. Ms. Richter?
No, thank you.
All right, you may be seated. Thank you. Mr. Christian, you ready to call your next witness?
Yes, we call Wade Moore.
Welcome, Mr. Moore. Thank you. You swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You may proceed, Mr. Christian.
Thank you. Cue this route.
It is. I apologize.
That's all right. Wade, can you state your full name for the record?
Wade Levi Moore III.
And as I asked Richard, can you give me a brief summary of your education and experience in oil and gas?
field?
Yeah, education, a Bachelor of Science degree from Texas A&M University. Been practicing landman work since 2012. I'm a certified AAPL member, American Association of Petroleum Landman. So that's my education.
And how long have you been working as a landman?
Since 2012.
And have you worked in jurisdictions other than Idaho?
Yes, Texas, New Mexico, Colorado, a little bit in Florida, and then Idaho.
Okay. You made a declaration in this case that it's part of the application materials, correct?
I did.
And you reviewed it, and is there anything that you wish to change?
No, sir. I reviewed it. Nothing to change.
Okay. You were you the person responsible for putting together the updated maps, which are exhibit SR06?
I have been responsible for updating the maps. Didn't initially create the maps, but I have taken ownership of the maps to keep them updated.
And to your knowledge, does exhibit SR06 match up with the updated owner list, which is exhibit SR05?
Yes,
In the sense that the highlighted tracks are now leased tracks, and you've added highlighting tracks that have been leased since the application was filed?
that's correct.
Okay. Mr. Piotrowski asked Mr. Brown some questions about the path of the wellbore and the path of the flow line. I think we handled the question of the path of the wellbore. On the subject of the flow line, can you give me your view of where the intended path of the flow line is?
It's in the path right now. Is to go due south out of 62. Utilize roads to go east.
And would the flow line cross onto any part of parcel 110 or run along the property boundary?
It would hug the property boundary of 110.
And is that the railroad's property?
It is railroad property.
Okay. I asked Mr. Brown this question. Is it possible that an alternate route may be required?
It's highly possible. Yeah.
Okay. And Mr. Brown said, to the extent you bore and run a flow line anywhere, you try to stay on the property line. You agree with that?
Yes. Yes. And yes.
You were the person mostly responsible for dealing with the pre and post application certified mailings. Is that right?
Yes.
And also the pre and post filing published notices to uncommitted owners.
That's correct.
Okay. And exhibits. Give me my head here. SR 03, sorry, SR02 and SR03 and SR04. Are those the certified mailing receipts from the mailings you conducted and the affidavit of publication from the publications to uncommitted owners?
Yes. I'm trying to recall numbers of exhibits, but yes, those are the certified mailings.
Okay. Well, if I can pull it up, I can. There are two things that are not included in those exhibits that I would like to ask you. One is the pre-filing notice of intent to develop to committed owners. You recall we did 2 publications before we filed.
Yeah.
One of them, for the record, is in exhibit SR01 at page SR127. And then the pre-filing notice of the application is actually in the docket at docket number 11. But in any case, you supplied the certified mailing receipts and affidavits of publication to me.
That's correct.
Okay. And the updated owner list, which is at exhibit SR05, does it reflect leases that have been taken since the application was filed?
I'm not sure what's been updated since the filing. I mean, we have an updated spreadsheet. I don't know what's been
Okay.
supplied since we filed. The spreadsheet has been updated.
Yes. One moment. That's a similar question to what I asked. Are you involved with the land team in pursuing and taking leases in the spacing unit before the application was filed?
Yes.
About how far back did you start working on the unit?
Well, I've been a part of this for a long time, but it's since 2022 is when it got serious. So I've been involved with this area since 2013.
Okay, and it's at least since 2022, did you work directly with potential lessors?
Yes.
And then work with other landmen in the unit?
Yes, I did.
And who were those?
Chris Matthews, Travis Boney, and Butch Clancy.
Okay, and about how often would you meet with those people and review your efforts?
Couple days a week. Minimum once a week.
Okay. That's all the questions I have.
Thank you. Mr. Piotrowski, cross-examination.
Thank you. Mr. Moore, do you know what percentage of the acreage has been leased in this spacing unit? Roughly?
Roughly 61%, 62, somewhere in there.
So 38 or 39% of the acreage was not willing to accept your terms, right?
As of right now.
Right. Did you offer any of those unleased owners a higher royalty rate?
No.
Did you offer to increase the bonus payment?
No. So we'll go back to your question.
Sure, absolutely. Let me come at it this way. You told me there was, I believe you said there's one property owner who got a royalty higher than 1/8.
I said that.
Oh, I'm sorry. Mr. Brown said that in his declaration. Are you aware of anybody in this spacing unit that's the subject of today's hearing who is going to receive a royalty greater than 1/8?
Maybe.
Okay. As a landman working in Idaho, let's just focus on Idaho. Have there been circumstances where you were involved in negotiations that gave a landowner more than 12.5% royalty for the gas well?
In the state?
Yeah.
Yes.
What about here in Southwest Idaho?
Yes.
Okay. And the 1/8 royalty for the base entitlement, that's literally the minimum that the state allows you to offer, right?
That's the baseline.
And you're suggesting to the department and to the hearing officer that the objecting homeowners are only entitled to a royalty rate that 39% of the property owners rejected, right?
You can say that.
Okay. Have you ever seen what happens if you go to landowners and you say, what if we made it a 25% royalty? Have you tried that?
No.
Did you go to anybody in this unit and say, we'll give you 18% to see if that would work?
To try to get someone not, well, here's the deal. I don't know. I wasn't involved in every negotiation.
Okay.
So I don't know if these other landmen did that on their own.
Did you do that?
I did not.
Okay. Did you offer any of the property owners that you talked with or communicated with in any way in this spacing unit? Did you offer any of them more than $150 per acre
No,
on the front end?
No.
Have you ever offered more than $150 per acre in Southwest Idaho gas leases?
I have not.
Okay. But you have done royalty rates higher than that.
We have.
Okay. And if Mr. Brown testifies as he has, that there was at least one property owner who got a royalty rate higher than 1/8, would you agree then that that royalty rate, whatever it is, if Mr. Brown approved it and swore to it, it's reasonable, right?
If he said it, yeah. Like I say, I wasn't involved in every tract, so.
Okay. So a royalty over 1/8 might be appropriate in some circumstances for this spacing unit. Is that right?
Well, there's lots of things involved. I don't know who the landowner was
Okay.
or what the position of the landowner had in other areas, so.
Well, in America, generally, if we're trying to buy something, we can't get it, we offer more money to try to induce the seller to sell to us.
Maybe,
Did you try that?
well, it depends on what you're trying to get. At some point, you
Someone asked you, sir, did you try it?
Objection asked and answered.
Overruled. You may go ahead and answer the question if you can.
I did not.
Okay. So at least from your experience, you offered a 1/8 royalty and $150 per net mineral acre signing bonus. And 38 or 9% of the sellers, people who could give you a lease or acres that could give you a lease, said no. And you're here today saying that the offer that 38% of sellers rejected is a reasonable and fair offer? You think that 61% of something as important as as people's homes is proof of reasonableness?
I don't understand the question, but I don't understand. I don't know where you're going, so I don't have any.
I'm asking you, but the law is kind of ambiguous. It says these terms have to be just and reasonable. And a term of more than 1/8 might be reasonable here, right?
It might be.
Okay, you can't rule out anything over 1/8 as being unreasonable, can you?
I'm not that guy to do that.
Okay. And so if the one person who Mr. Brown says got a royalty rate higher than 1/8, all his declaration says is a large acreage owner.
Okay.
Okay. Do you know how many total acres are in this spacing unit?
400.
Okay. And so I can figure it out here myself real quick. If we do 0.38 times 400. So you had 152 acres that didn't sign a lease here. That's 38% of 400. Is anybody in this unit own more than 152 acres?
Not inside the unit.
Right, yeah, just the spacing, that's all I'm asking about. Okay, and so whatever was a large landowner who was able to apparently negotiate a higher royalty rate, he must necessarily, within the spacing unit, have had less than 152 acres, right? Because nobody's that big in this unit, right?
That's all right. Yes.
Okay, so if a higher royalty rate is reasonable because somebody has more acres, then wouldn't it be fair to say that it's reasonable for 152 acres? Terrible question, I'll withdraw it. Does the size of a unit or does the size of a tract tend to influence how much bargaining power that landowner, mineral owner has?
Well, sure.
I mean, you have no choice but to deal with 1 acre and even smaller lots in the suburbs, right? Is it fair to say that it's more efficient and therefore better for you as a landman and for the companies you work for if they can get large tracts to lease voluntarily?
Yeah, it's a lot easier. Sure.
Right. And yet you didn't go to the 152 people who wouldn't lease and try to offer them any bonus or any benefit above and beyond the base entitlement.
You can't blanket statement that because a lot of these, we have documents of refusal, like leave me alone. I don't want your
Okay.
money. I don't. So you can't just say everyone's in the same boat. So when you get to a point of rejection,
Okay.
and the anti, if you will, you could offer them. I don't know. I don't think you will offer them outside of your. You make it unproductive.
Is it the landman's job, is one of his jobs, or her jobs, to secure as many leases in the target spacing unit as they can?
That's our goal.
Okay. And why wouldn't you offer more than, for instance, a 1/8 royalty when people say they don't, they reject your offer?
It's called economics.
Okay, but you can pay more than 1/8 and it can still be economical, right?
Well, it depends.
Okay.
Again,
Depends on what?
well, it depends on the unit, depends on the reservoir, depends on lots of things.
Okay. What's a reasonable royalty rate for this unit?
I'm not the geologist.
So you don't know what a reasonable.
Reasonable road, so 1/8 is reasonable
Why do you say that?
because of what it's gonna take to get this well produced.
So you think what would it be, an 88% return to the operator? The 88%, 87.5% of the receipts should go to the operator, and you think that's reasonable, right?
I do.
And did you base that on an analysis of the likely return from this well and its likely costs?
I'm not the guy that does the math,
Right.
but I'm just saying, if you wanna produce your minerals, there's no way to produce your minerals on a less than 5-acre tract.
I understand that. That was not what I asked. What I asked was, are there circumstances where a higher royalty rate is reasonable?
There are circumstances.
Thank you. That's all the questions I have.
Q.
I'm sorry, let me back up. Okay, may I, please?
Yes,
The gathering line, I just want to make sure I understand this.
sure.
So looking at exhibit SR06, it's up on the screen. The well site will be in what's marked as lot 62.
Yes,
And assuming there's a need for a gathering line, that the gathering line would run south through lot 62, but on the property line. And the map, it's hard to read on the screen, but I looked at it, it says 16th Street at the bottom there.
Mhm.
Is that the point at which, from that point on, the gathering line would follow roads?
correct.
And is that because SROG has leases for the roads?
We have leases for the roads.
Okay. So the gathering line should not cross any unleased property, right?
Well, we hope it don't.
Right. Other than a mistake being made and putting it in the wrong place, it should be on the line between, it should be either in lot 62 or on the line between 62 and 110, is that right?
Well, that's the goal.
Okay.
So it's more than just that little spot. We have another mile to go. So
What do you mean you have another mile to go?
to get it to tie into production.
Oh, right, to get to 16th Street.
Yeah.
You're
That's
gonna go
not-
down you're gonna stay in unit 62 until you get to 16th Street.
62 to get 16th, then you gotta go east. Yeah,
Right, but you'll follow, your testimony earlier was you'll follow the roads at that point, is that right?
that's our current goal.
Okay. Do you have a traffic plan for the operations period, the drilling period?
I do not have a traffic plan. I have spoken with the Highway District 1. And their recommendation is to utilize 95 and then come off 95 on the 16th.
So 95 to 16. And that would give you access to unit 62?
Track 62.
Track 62, thank you. Thank you, that's all the questions I have.
Thank you. Ms. Richter, any cross-examination?
Briefly, yes. Would you like me to relocate?
You're free to do it from there if you'd like.
Well, just because I'm set up here. Mr. Moore, I just have a couple questions for you. In your declaration, this is paragraph 7 of SR 124, the record. You state, unfortunately, prior to his untimely passing, Chris did not share all of his notes regarding his efforts in the area, and it has been necessary for us to construct a resume of efforts for his work. Can you clarify whether you constructed the resume of efforts or reconstructed it? Can you just explain that work?
Sure. So Chris, so do I need to walk you through how I got this? Okay, thank you. I'd rather not. Reconstruction of what his notes said. I did not make up his notes for him. I took his notes and put them on a spreadsheet.
So okay, so you built, just to rephrase what you said for clarification, you compiled the resume of efforts based on the notes, on his notes.
Yes.
Thank you. And then briefly pivoting, in your experience, is a 1/8 royalty standard in the industry
Standard in the industry as a whole?
in general?
It's not standard in Texas.
Sure.
In Idaho, it is standard.
I know. Thank you. That's all. Thank you.
Thank you. Any redirect, Mr. Christian? Briefly.
Mr. Moore, Mr. Pietrowski asked you some questions about the lease bonus and royalty rate. The highest bonus paid in the unit before the application was filed was $150, is that right?
Yes.
$150 per acre.
Yes.
Okay. When you started working in the area, like 10 or 12 years ago, do you recall what lease bonus was typically being offered to and accepted by lessors?
We started at $50, then we went to $100, and now today we're at $150.
Okay,
So it's been a progression.
okay. And in this unit, 61 or 62% of the people voluntarily accepted $150 and a 1/8 royalty. Is that right?
Objections. The question asked about people rather than acres. All we'd have data on is acres.
Apologize. The holders of 61 or 62% of the net mineral acres in the unit accepted $150 and a 1/8 royalty.
Yes.
Do you know about how many owners that includes?
I'm gonna guess. I'm trying to see my spreadsheet in my mind. That would be, I'm gonna say around 200.
Okay.
I don't have a firm number on that, but
And you testified earlier that some people simply refuse to engage with the landman
absolutely.
and said, don't speak to anyone.
Yes.
And are those people indicated on the owner list? Yeah, I think it's SRO2, the updated owner list.
Okay.
Is there the people that refused, are they designated on a spreadsheet?
Yes, it identifies them as refuse.
Okay. I don't think I have any other questions for you.
Any recross, Mr. Pietrowski? Yes, please.
Mr. Moore, when we look at your spreadsheet on your resume of efforts, that lists every platted tract separately, right?
Every platted tract separately. Help me understand what that means.
Sure. In property development law, we go to the county and we submit a plat for a piece of property we want to subdivide.
Okay.
And that plat becomes part of the official records of the county, and that's how the property records are kept. Is this person is the owner of, and these numbers aren't accurate, but it'll be a map like this and show this person owns number 66, which is Y number of acres.
Right.
Okay. And so your spreadsheet is a list of the owners But the total, the 61% that we were talking about earlier, that's referring to the acreage in the unit, right?
We track that spreadsheet by acreage, not people.
Right. So you got 61% of the acres approximately.
Right.
In this unit, you got their owners to agree to a lease.
Correct.
Okay. Now, your resume lease lists all of them individually, right?
Yes.
For each tract, you've listed that tract
Yep.
and who owns it and the results of your efforts.
Yes.
Okay. And anybody could go through and say, okay, based on the spreadsheet, it looks like this number of people leased, this number of people didn't lease. Would it surprise you to learn that 252 people in the spacing that chose not to lease?
Yeah, I don't know that number.
Okay, that number can be easily determined by just counting up the spreadsheet, right?
Totally.
So the hearing officer could determine whether or not it's true that 252 people chose not to lease. And you testified before that about 200 people chose to lease.
That's what I said. Well, if you heard me say, I'm just guessing.
So I'm trying to ask, because the assumption seems to be that 61% of acres is a big deal. But if my numbers are right, wouldn't 61% of the people be an equally good deal?
We don't lease people, we lease acres.
Okay. And so you don't care about how many people you leased from or to, right? You just care about the acres that you leased.
People own acres.
Right.
I don't lease the person, I lease the acres.
Right. You're not making any claim that integrating in this setting is some sort of pro-democracy movement because 61% of people want to produce that oil, are you?
Pro-democracy.
Yeah.
What does that even mean?
Okay, does it have anything to do with the oil and gas business? To your knowledge as a landman? The democratic principles of America, does that get reflected in how you go about signing contracts? For
I have no idea what you're trying to say.
Okay, so your point is simply, you've got 61% of the acres. Why does that matter to you?
Because my goal is 55%.
Okay.
Per state law.
So your goal is established by state law?
Sure.
Okay. Now, you said a 1/8 royalty is standard in Idaho, other than the Southwest Idaho oil fields, which have mainly been developed by Snake River and its predecessors. Have you looked at leases for minerals in the rest of the state?
Have I looked at leases for minerals? Knowing we were involved with taking leases in other areas of the state that's not the Southwest, those were 1/8 leases.
How many of those have you done in Idaho?
Just very few.
Okay. Have you looked at the leases that other mining companies have for mineral rights in, say, Southeast Idaho, where there is major mining going on?
I don't deal with mining.
Okay. And did you look at the mineral leases that are sold for people developing other natural resources across the state? Did you go up north and look at leases there?
There's not oil and gas related, so I don't bother.
Oh, I'm sorry. So you didn't look at anything that wasn't an oil and gas lease?
That's correct. I deal with oil and gas.
Okay. And so you don't know what a standard mineral right royalty rate is in Idaho, other than for Payette County for oil and gas.
I'm producing oil and gas.
But that's all you know about, right? Here in Idaho.
That's my expertise.
Okay. So you don't know what the royalty rate is for phosphorus.
I don't have a clue.
You don't know what the royalty rate is for gold mining or silver mining.
I've never done any of it.
You don't know what anybody in Idaho is selling their mineral rights for, other than here in Southwest Idaho in the oil and gas fields.
Well, are you selling them or are you leasing them? I have no idea.
A lease is the sale of a right to access. So, do you know anything about leases for any mineral in Idaho, other than oil and gas, and other than in Southwest Idaho?
No, I don't. This is an oil and gas hearing.
So have you settled on 1/8 because that's what the law says?
No, because that's what's reasonable for this area.
What in your mind makes it reasonable?
Because of what it costs to get this thing done.
You don't know what it's gonna cost to do this, do you?
I've been here 12 years.
What's it gonna cost to produce this well?
What is it gonna cost to produce a well?
Yeah,
We'll see when it happens. I have no
you
idea.
don't know what it's gonna cost to.
I can tell you it ain't cheap.
Sir, if you
So how
don't
do you
know
know?
the cost, you don't know the expenses, and you don't know the volume of gas that's gonna come out, and you don't know the price of the gas, you can't possibly say that 1/8 is the reasonable royalty rate, can you?
Sure, I can right now.
What if gas jumped 25% tomorrow?
That'd be awesome.
Right, and it would leave more room to pay the owners more money, right?
No.
Thank you. Economics is not your field.
Ms. Richter, any recross?
Thank you, sir.
No.
Doug, that was fun.
You are done.
Mr. Christian, do you have any additional witnesses?
No, sir.
Do you rest?
I do.
Thank you. We've been going about an hour and 10 minutes. Let's take a break here briefly. Let's take a 10-minute break. Let's plan to come back. Well, let's take 14 minutes, come back at 12:25. So we're going to go off the record. We're back on the record for our hearing today. The applicant has put on evidence and has rested now. So now's the time, Mr. Piotrowski, do you have any evidence you would like to put on behalf of the objectors?
We'd like to recall Mr. Brown.
Okay. And Mr. Piotrowski, before you begin your examination, I want to give you the same opportunity Mr. Christian had. If you want to make any opening remarks, you're free to do so. Otherwise, you're free to launch right into testimony.
Do you intend to allow closing? Or post-hearing briefs? I'd rather make my statements there.
Yeah, that's fine. Okay, thank you. Let me just remind you, Mr. Brown, that you are still under oath. You may proceed, Mr. Piotrowski.
I wanted to dig a little more, Mr. Brown, into the bonus payments that have been provided to some of the leases in this unit. Am I correct that some people, even though they had less than a full acre of property they owned, received a $150 payment with their lease?
I believe some lot owners received $150 an acre.
When you say lot owners, looking through the materials that your company provided, I see a fair number of lots that have a very small size, 0.16 acres. And then of course, well, we saw that could vary wildly from there. Do you think it was one of those smaller lots or some of those?
I do not know that. I do not know. Mr. Moore would know better than me as to what we paid lot owners versus, yeah.
Okay, so as you sit here today and you try to break it down on a per acre basis, what is the most that you paid one of these small lot owners per acre?
I can't answer that.
Okay. I want to make sure you understand my question. If you pay somebody $150, if we got half an acre, they got more than 150 per acre, right?
That's correct.
And in that very simple example, the per acre price would be 300, right?
If they owned a half an acre, that is correct.
Right. So if we take a person with a.
Excuse me, that would typically not be what we call a lot. So when I'm talking about lots, and I would defer to Mr. Moore, so I'm going to look for him to, if I say anything incorrectly, we consider lots like town lots or subdivision lots, which are in subdivisions. So that's when I say the word lot, I'm meaning like in a subdivision, a lot.
Okay. So you're really talking about smaller tracts that have been subdivided for residential use.
Yes. Yes, okay.
And in some of those cases, some of the leases provide for a $150 payment, even though the acreage is less than you.
Correct.
Okay. And if I want to make sure if we were to take, let's say, a quarter acre lot, I've lived on a few of those myself over the years, a quarter acre lot, and the owner got $150 as the lease bonus payment, the actual per price lease would be 4 times that amount, right? Or the per acre price.
That's correct.
Okay. And so as you sit here today, you're not sure what was the highest per acre payment that was made to any of the owners in this unit. Is that fair?
the purpose of paying $150 per lot is obviously if you want somebody to sign something and you offer them $5 to go through the time and trouble to review a lease and sign it, you probably wouldn't sign any leases. So the purpose of that is a blanket $150 per lot, and that's used in our industry in when working in subdivisions.
And when you say in our industry, are you referring to the industry both in Idaho and outside of Idaho?
Just working in subdivisions, and that would, yeah, you could say working in subdivisions.
Okay. So I want to make sure I understand your testimony. You're saying that the per lot payment industry-wide is for that purpose you expressed, right?
In subdivisions, you would often, for lots, you would pay a base price just because folks need to be, I mean, folks are not going to do anything for $5 or $10.
Right. And you're aware that here in Idaho, laws may vary elsewhere, here in Idaho, every integrated owner is entitled to that minimum amount that you've paid to other leasing parties, correct?
Ask that question again.
Wow, you're right. That's a terrible question. I'm sorry about that. So in Idaho, at least, do you understand that people who don't sign a lease, who instead choose the base entitlement as it's expressed in Idaho law, are entitled to the highest per acre price that any leasing entities, or the operator in this case, have paid for leases in this unit?
I believe that is, I'm not exactly precise on the exact wording.
Fair enough, and you're not a lawyer, and all of us can look this up. All of us who are lawyers can look this up. How many of the leases in this spacing unit call for a royalty higher than 1/8?
I'm sorry, see.
To your knowledge, how many of the leases in this spacing unit call for a royalty higher than 1/8?
One.
Okay. And do you know which lot or tract that was?
I do.
And which tract was it?
You gotta put up a map for me to.
Do you know who the individual was?
It was a private negotiation. I'd rather not put their name out there, but
all right, maybe I don't need it. Let's see if we can get where we need to be. Were you involved in that negotiation with that one individual?
Along with the landman.
Okay, and why is it that you offered more than 1/8?
That particular landowner owned acreage outside of the unit. It involved additional consideration for other lands, and his bargaining power was such that it resulted in him getting a higher royalty.
The approximately 250 property owners who didn't sign a lease, how many of them own land outside of the spacing unit but still within the Southwest Idaho potential oil fields?
I can't answer that, but not many.
And if you've let me take a different approach here. So the setting of reasonable royalty rates, it sounds like in your opinion, would also take into account these sort of extraterritorial issues, like this individual who had other land which you also wanted to lease. Is that correct?
Ask that question again.
Sure. The lease that you ultimately signed with this individual, you thought it was reasonable, right?
Business decision.
Right. And in that moment, it was a business decision that you thought was a decent one.
Correct.
Okay. In reaching that conclusion, you relied on matters that were not just limited to this piece of land in this spacing unit, right?
Correct.
Okay. So that individual had bargaining power and got a better deal, not because of the size of his lot in this spacing unit, but because he owned other property somewhere else.
It was considered.
Okay, was the size of his acreage within the spacing unit also considered?
Yes.
Okay. And do higher acreages often justify a better lease from the property owner's perspective?
We've signed over 1,000 leases in Idaho. And I recall less than 10 leases in the entire state of over 1,000 leases that were higher than an eighth royalty.
And so in 1 in 100 cases, it's reasonable to do a higher royalty based on your experience that you just expressed to me, right?
Based on the business decision.
Right. Now, somebody in this particular drilling unit, spacing unit rather, told you I've got 250 acres out of the 400. Would that make you seriously consider whether to raise the price for the lease to increase the royalty and or the bonus payment?
It's speculation.
Right. So you don't know. You can't know.
There's not a royalty owner in this unit that has there's not a royalty owner that has near that much acreage.
Right. Can you answer the question, if there was, would that have been a basis to convince you to pay more?
Speculation.
Okay, so you don't know. You can't know without more details. Is that fair?
That's correct.
Okay, so as you sit here today, the 252 acres that are owned by non-consenting owners, you don't have an opinion one way or the other whether the lease price should be higher than it is for a quarter acre owner.
Ask that question again.
Sure. As you're sitting here today, you've said you don't know, you can't speculate about whether the 252 acres owned by non-consenting owners would justify offering a higher royalty rate.
I don't believe there's 252 owners that are unleased, and I don't believe there's any owners. I think the 1/8, given the risk of what we're doing, and based on the history in Idaho and leasing history, I believe 1/8 is very reasonable.
And that's an answer to my question, sir. You couldn't speculate what a 300-acre property owner would be worth in a situation like this, but you're prepared to speculate about the 250 or so acres that have not been leased here. Why is speculation okay with you in one circumstance but not the other?
You said 250 acres that's unleased, and there are not 250 acres that are unleased.
Sir, there's a 400-acre spacing unit.
And we've got
You've leased 60%.
62% of it.
I'm sorry, you're right. It's not 252 acres. It's 250 people I counted.
And there's not 252 people. I'm not sure where that.
Well, let's say 160 acres then. If somebody had 160 acres, would that give them bargaining power?
I've already told you that there's not anybody that.
That's not the question I answered. I'm asking you a hypothetical question. If somebody in this unit owned 160 acres, would it be worth more?
I'm not going to speculate. I'm going to deal with reality. We've made every effort to be fair and to be reasonable.
Okay. But you don't know one way or the other if the bargaining power of those individuals is enhanced when it's collected, when it's brought together in one. You don't have an opinion about that?
I told you I'm not going to speculate. I'm dealing reality.
Have you ever paid less than 1/8 for a royalty in Idaho?
I'm sorry?
Have you ever paid less than 1/8 for a royalty in Idaho?
No, I have not.
Okay. You know, there's a saying in my line of work, which is mainly employment law, that when you're getting paid minimum wage, it means they're literally paying you the minimum they can. Are you literally paying homeowners in Southwest Idaho the minimum that you can in order to get your wells drilled?
I'm not going to. That.
Why not? I mean, you can answer the question. You're capable of answering the question.
we bring a very transparent business here. We are very transparent with the public. We try to act very safely. You can look at our safety record. You can look at the comments and our current royalty owners that are getting paid. We're now paying over 300 royalty owners in the county. Satisfied royalty owners that tell me that we are doing good things in the community. And all I'll say is that we are being very fair at a very tough business.
The sale and purchase of real estate is also a tough.
I'm
business,
sorry?
right? The sale and purchase of real estate is also a tough business, right?
I'm not in the real estate business. I'm in the oil and gas business.
Okay. And as you sit here today, you're unwilling or unable, this matters, but you're unwilling to speculate about whether a larger collection of property, whether a larger acreage would justify a better price.
We've already had testimony that
I'm asking you, is that your testimony that you are unwilling to speculate about whether that is correct or not?
I'm not going to speculate things that aren't reality.
Okay, thank you.
Mr. Christian, any cross-examination?
Yes, thank you. Mr. Brown, has Snake River integrated other units in the Payette County area? Other space, have you gotten integration orders for other spacing units in the area?
Yes.
Okay. And then some of those, has the entitlement for town lot owners, sub 1 acre lot owners been a flat rate?
I believe so. Yes.
Mr. Piotrowski asked you questions about the reasonableness of the royalty rate. There is some testimony in your declaration about what goes into your determination that an eighth is reasonable. Has every well that Snake River has drilled in the basin been successful?
No.
Is there a risk that the well that will be drilled in this unit may not be successful?
Yes.
Has how much has Snake River invested in seismic exploration and permitting and everything else that goes into getting to this point for this unit?
For this particular unit, almost $1 million.
How much does the average well in this area cost you to drill?
I'm sorry.
How much does the average well in this area cost you to drill?
To drill and complete approximately $3 million.
And can you readily get drilling rig and service companies here?
Very difficult. We're 400 plus miles to 600, depending on where drilling rigs have come from California a couple of 3 times. So equipment is everything we do is 3 to 4x what it would cost us in other regions.
And does Snake River do Snake River and its working interest partners bear all of those expenses?
Yes, we do.
The royalty interest don't bear any of that expense.
Mm-hmm.
I don't have any other questions. Thank you.
Thank you. Ms. Richter, any questions?
Just one. Mr. Brown, in your negotiations, have any of the mineral interest owners made you a counteroffer?
I supervise, so direct negotiate. Typically, in that negotiation process, there will be back and forth on occasion. And but me personally, so your question was to me personal, correct?
You are correct. That is what I asked you. And I guess I should rephrase to your knowledge, if any in Snake River's negotiations have the mineral interest owners made counteroffers?
I believe so.
How often are you receiving counteroffers?
I can't answer that specifically, but it does occur.
frequently or
I'm sorry.
frequently?
Uh, Probably.
Thank you.
Mr. Piotrowski?
Nothing further.
Okay, thank you, Mr. Red.
We have no additional witnesses.
Okay, thank you, Mr. Piotrowski. Do you rest at this time then?
Were the exhibits submitted?
Pardon me?
Were the exhibits submitted by stipulation?
All the exhibits were admitted.
Then we rest.
Thank you. And just so I'm clear, you didn't offer any.
We have not offered any exhibits or.
But all the exhibits that were offered by the applicant and by Department of Lands have been admitted. They're all part of the record. So you rest.
We rest.
Thank you. Ms. Richter, it's IDL's turn. Do you have evidence you'd like to present?
We do not. I just had a brief statement to make if that would be possible.
Okay.
Thank you. So the Department of Lands intends to rely on its pre-hearing statement. And for the folks gathered here today, the pre-hearing statement and all of the materials that have been discussed here today are posted on the Idaho Oil Gas Conservation Commission website for the hearing. There's an administrative hearing page, and the whole docket is there publicly available for you to access and read all of those documents and look at the exhibits if you'd like to. I would also like to correct a typo in the pre-hearing statement on page 2. It's a quote of the spacing unit order. Bullet number 2 indicates that the unit is in Canyon County, Idaho. That is incorrect. We are in Payette County. So just wanted the record to reflect that correction. And IDL has received a few, I believe, 3 or 4 written comments to this on this application. Those have been provided to the Office of Administrative Hearings, and those are also posted on the website currently. Mr. Hearing Officer, there may have been 2 that were submitted to OAH this morning or last night that you might not have a paper copy of, but those have been submitted.
Thank you. I did see before we started that I received an email that included one comment that just we received this morning. If there's anything further, that obviously will be added to our docket and will wind up in the public docket that'll be available for everyone to see. But yes, we did receive some recent comments.
And that is all that I have.
Thank you. Mr. Christian, do you have any rebuttal evidence that Snake River wants to submit?
I do not.
Okay, thank you. So that will conclude the evidentiary portion of the hearing. We've now closing the record on the evidentiary portion of the hearing. Now, I think it would be quite helpful for me to have proposed findings and conclusions from any party who wants to submit them. I would give folks up to 7 days to do that. But I also want to give you the opportunity to make any closing argument that you might want to make. We can do that either here now, or we can do that in writing as part of the findings and conclusions. Let me start with you, Mr. Christian. Do you have a preference? Would you like to make some closing remarks now?
I think if we're going to do proposed findings and conclusions, it would be more productive to include it with that in writing.
Okay, Mr. Piotrowski, do you have a preference?
No, I don't really have a preference.
Okay, thank you. Ms. Richter?
I agree with Mr. Christian that in writing is typically more helpful.
Okay, so what we will do then is all parties are allowed to, but not required to submit to me in writing within 7 days of today. any closing remarks they want in writing, and any proposed findings and conclusions they think ought to be included in my recommended order that would support their position in the case. That will be available to folks until December 24. If the parties want additional time beyond that, I know there are holidays coming up. If you would prefer some other deadline, let me know now. Mr. Christian, what about you?
I think I can accomplish the 24th.
Mr. Pietrowski?
I'm not sure that I can. We may push it out to 14 days, which could be the 31st.
Yes, yes. Ms. Richter, would the 31st work for you?
It would. I would note that per statute, the decision from the is due within 30 days of the hearing.
Well, what we have typically interpreted that statute to mean is that the record closes when we get any final remarks. And so if there are written closings, then we have interpreted to mean that 30 days from those filings, the final decision would be due. So that would make the final decision due under our interpretation no later than January 30. It would be my intent. And just so folks know what happens here. So the parties all get to submit additional argument to me about why they think the evidence that we heard today supports their position here. I then am tasked with providing a written recommended order to the administrator at Oil and Gas, who then issues a final order. That final order has to come within 30 days of the close of our record. So that will happen no later than the end of January. My recommended order will come out no later than mid-January so that the administrator has time to consider that before that happens. And all of the things that get filed by the parties will be put on that public docket. So if anyone's interested in following the proceedings after this hearing, as Ms. Richter said, you can go to the Oil and Gas website and you'll be able to see everything that the parties submit. You'll be able to see what my written recommended order says in mid-January, and you'll get to see the final order that the administrator issues by the end of the month. So before we conclude the evidentiary portion of this hearing, then, are there any other additional issues we need to take up, Mr. Christian?
No, sir.
Mr. Pietrowski?
Not that I'm aware of.
Thank you. Ms. Richter?
Just one moment. No, to your question, I have no more evidentiary issues, but Mr. Thumb just wanted everyone to know that as well as going to the OGCC website for information, one can also sign up for emails to get the information directly sent to them from the website.
So what will happen is you will get a notice that says we have posted something new to the website. So I know people don't want to go and check the website every single day. So you can sign up for a written notice and put your email in, and you will receive an email that says a new document's been posted, and then you can go find that. So I know it's burdensome for some people to go every day and check, but there's a mechanism by which you can just get a notice that we've posted new documents related to this.
Okay, thank you. I appreciate that information. So when we scheduled this hearing based on, people don't always know how much time they're going to need to put on testimony. Sometimes the witness goes very quickly, sometimes it takes longer. We anticipated needing more time. So this hearing was scheduled to start at 11 o'clock today. The evidentiary portion was scheduled to go no later than 5 p.m. And then we have a public comment period that was set to start at 5 p.m. But because we finished much sooner than anticipated, and because a number of people have shown up here today and obviously have some interest in this proceeding, if anyone who's present now wants to make a public comment, you're allowed to do so. I'll allow anyone who wants to do that now. Also, because our notice said there would be public comment time available at 5 p.m., we will at least if we conclude here before then, we will at least reopen the proceeding at 5 PM in case there are folks who weren't able to attend now, and they'll have an opportunity to make their comment as well. So is there anyone here who would want to provide comment on their views on this application? Yes, sir.
Yes, I will.
Okay. What I ask you to do before you make your comments is to please identify yourself. And then make sure that if everyone, I want to ask to make sure everyone who attended, if you would make sure you've signed in on the sign-in sheet, but confirm that you have signed in on the sheet after you tell me your name. And then you're free to proceed. I only ask that you try to keep your voice up so that it's picked up by the microphone and it'll be part of our record.
I have signed in on the sheet. My name is Charles Adi. I live at 1208 Jessica Avenue right here in Fruitland. And I have several objections to this. Really they all have to do with the fact that the proposed drilling site is very close to residential areas. There's going to be a lot of people that are living very close to there. And I think there's definitely some risks that are involved with oil and gas, with having wells. I'm just going to read what I wrote because I think this is better. The spacing unit is very close to many residences in the city of Fruitland and Payette County, and drilling and extraction operations, which have some inherent environmental risks, should not be conducted so close to people's homes. And then the next issue that I have with it also comes straight from that one. The presence of an extraction facility could result in the reduction of property values for citizens in Fruitland and Payette County. So I think those are two very important issues to homeowners. And my objections are really mainly based on the fact that the drill site is so close to where many people live. So those are my comments.
Thank you, sir. I appreciate that. Anyone else? Yes, please.
Can we bring up SR6 on the screen?
Mr. Christian, could you do that?
One moment.
Mr. Hero, while we're waiting for that, we may either now or at 5 o'clock see some of my clients providing public statement. I want to let you know that we made a conscious choice not to present it as evidence, but some of them do want the opportunity to address you, so you may recognize some names.
Thank you.
I want you to know they're not acting against council's advice.
My name is Poppy Enos. I live in the Rivercrest subdivision. There, but my concern is that when we bring up the map, this is going to be right behind us, the well site. And in the subdivision, we have one entrance and one exit. If the concern is if something happens, then we're going to have several elderly people that live in the back of our subdivision not be able to get out if there is some kind of fire or flaring. Having been through some the wildfires in California, people aren't prepared to get up and leave. It could be a very, very bad thing if people can't get out of. This is the only entrance and exit. We have houses all the way down here. We have elderly people living in some of these areas. So my concern is that that there isn't an access road where people can get out if they need to get out. as an adult of a certain age, we know things can go wrong. Not very often, but they do. So that would be my concern.
Thank you for sharing. I think I saw at least one more hand. Yes. ma'am.
I'm Darlene Walker. I live on Oak Avenue. And I am not against drilling. I've had many leases through the years. But I'm against where they're drilling. It should not be in a subdivision where people live. And also right in the heart of Fruitland, business area is there. And another thing, I got these papers that they sent, this oil outfit sent me with the seismographs. And it looks like most of this is under our property. They're pockets of gas. And it also says that they're going in sand to get the oil. Sand shifts. So that creates sinkholes. So that creates a problem with our homes getting off kilter. And another thing, our subdivision is, I would say, 100% gas. We have gas furnaces, and also a lot of people have gas ranges in there. If there should be a problem of any kind while they're drilling, and another thing I'd like to find out is when, I can't remember the word they said, but when they're searching or they're boring through, what's their process? Is it water, just like fracking? And another thing, like Poppy says, that's our home, that's where we live, and we don't need to be fearful of losing our homes or our lives due to a possible upset. And another thing I have to say, I used to live in New Plymouth, and after you cross the Black Bridge and go on to connect on Highway 52, there is a site there, and where it has been drilled, and apparently this is where the pipeline is, and they apparently have a pop-off valve when the pressure gets so high. And I happened to be there when it blew, and the fire went up at least 50 feet. And that, we just can't afford to have anything like that happen where we live.
Thank you. Any other folks like to comment? Yes, sir.
My name's Joey Ishida. I'm a Payette County resident. And my concern also is the fact that you're drilling in the middle of the city of Fruitland. In the past, I know that the city, several council members had objected to drilling in the city. And I'm not sure, but were there setbacks set at that time? And are we following the setback rules that are currently on record, or are we making new ones up as we go?
Thank you. Yes, yeah.
I'm Shelley Brock. I'm the president of the board of Kaya. We've been working on this issue for about the last decade. I'm also a longtime healthcare professional, mom and a grandma, and that's why I got involved in this 10 years ago. I'm gonna have to kind of read this because I'm not prepared to speak this early, but in Snake River's filing, I noticed that they said that objecting property owners only represent about 1.5% and roughly 6 acres of land. But I just want to point out that these are just a handful of people that really understand what's happening to them in this integration application. The others, among the more than 250 tracts of unleased land, which likely could represent up to 1,000 people when you consider families living in those properties. They won't get what's being done to them until it's too late. So we're relying on you, on the officials that are charged with protecting people, not just the oil and gas, but the people that are exposed to it. We're depending on you guys to do the right thing. We want this commission to apply to all the forest people, or now it's the language has changed to base entitlement landowners, the same rights that were negotiated with us on prior applications over the last few years by this same company, and before them by their now bankrupt former partner, Alta Mesa. These include, the application is really fuzzy. I read all through that. I agonized over it. In one place, they say they're not going to do any drilling activities on the surface of integrated acres, and any surface activities must occur under a surface use agreement with the leased owner. But later on in the application, it says the operator shall avoid to the maximum extent possible any use of surface lands belonging to integrated owners. Where such use cannot be reasonably avoided, the use of surface lands and compensation of such use shall be governed by state code. So we want to ask that you specifically order no drilling or surface use and no subsurface use on the land of these basin titled owners now. Nothing, period. That's the only way to make sure that these folks are at least remotely protected. And they, the way it's worded right now, there is none of that. Also, we know that larger setbacks are desperately needed from these adjoining high density subdivisions, and there are a couple of schools too that are in close proximity there, given the insufficient state and county setbacks. In the Argus Observer this morning, I noted that Commissioner Kelso made a statement saying that the Payette County Commission had just recently passed increased setbacks from city lines. But unfortunately, her statement was somewhat misleading. Because they just proposed an increase from 300 feet to 500 feet, which is woefully inadequate, since most scientists and healthcare officials across the nation say that setbacks should be at least a half a mile in order to prevent the health impacts that come from this. Ms. Kelso also used the words exemption, variance, and waiver in her statement, which those of us who've been dealing with this stuff for a number of years know that translates to if the oil company claims that abiding by these setbacks is cost prohibitive for them, they will be exempted from having to adhere to them. The last thing, the commission stated that this ordinance change, that's what it would be if they increase those setbacks, still needs to go through the rest of the public process before being codified into law. So setbacks really haven't been, even though they voted for it, they've got a long ways to go. And 500 feet just isn't enough. At a recent public meeting, I believe it was in front of Payette County P&Z, but I can't swear to that. Mr. Brown reportedly claimed that they can't directionally drill in this spot because the geology here doesn't support it. But several other wells, including the Fallon and Barlow wells, have already been drilled directionally in the same geology. One 1,700 feet directionally, the other one 1,400 feet plus. And Snake River has already applied to directionally drill in this application. They don't say how far, but it's in their application. So I don't understand his statement. Some other things that we really are hoping for here that you've given us, we've been given in negotiations on previous applications, is that they're asking for a 5-year primary lease with an option to extend that an additional 3 years. We want to ask that you order them, specify in the orders that this integration application and drilling here should take place for no more than 3 years, at the most, primary term, 3 years with no extension. And that was given to us in the past 4 orders. People were given that in the past 4 orders. It was shortened to 3 to 4 years. So I don't understand why they're asking for such a lengthy term right now. The $150 bonus per net mineral acre has been discussed here. In some of the previous applications, that has been pro rata. In others, it has been a base minimum. We would ask that these people are paid a base, no matter how small their acreage is, less than an acre, of $150. I guarantee you it will cost them a lot more money than $150 to go to an attorney and have this contract and all this stuff that's going on examined by an attorney. So that's a pittance. Snake River claims that they won't need to frack here, so we want them to put that in writing. That was ordered in a 2021 integration order by the Secretary of IDL, so please order no fracking. We really appreciate that Idaho Department of Lands recommended limiting this application to one well, as was ordered on a prior application in 2021. And we've talked about the drilling and operational traffic that could seriously impact these adjacent subdivision boundary roads. I think really good arguments for that were made, so something needs to be done about that to ensure that they can't use those roads for their traffic. And in fact, someone said they don't know how they're gonna get their big trucks around the corner they're coming off of that subdivision. The application also states no additional bonding is necessary. Well, I think that's ludicrous. This is a huge application. We've never seen anything like this. This is impacting hundreds, literally hundreds of different families in this small section, relatively small section. Hundreds of non-consenting people are in there too. The well is going to be drilled right in the center of the city of Fruitland, surrounded by schools and high-density subdivision. Additional bonding is absolutely warranted. And in closing, I just want to say that in the application, it also stated that base entitlement owners retain any private right of action they have in law against the operator for any future harms. I can tell everyone in this room that we had to fundraise for 3 years in order to raise over $100,000 it took to fund our winning 2018 lawsuit defending other forced pooled property owners. How many private citizens have the resource to do that when things go wrong, as they far too often do with this industry? That's all. Thank you.
Thank you. Is there anyone else who would like to speak? Seeing no further hands, I want to thank it. I do see a hand, sir.
So I've got some testimony on behalf of the city. Is that more appropriate at 5 or now?
You may do that now. We're taking public comments now, so
Okay.
it's.
Thank you. My name is Stuart Grimes. I'm the Fruitland City Administrator, so I'll be giving testimony on behalf of the Mayor and Council. Just to start off, I realized from a previous hearing that I gave testimony that it's kind of supposed to stay focused on the actual application being discussed, which is the integration or pooling the uncommitted owners. So I'll try to stick to that, and if I start to sway a little bit, it's just to kind of support it. But so the city of Fruitland is opposed to the approval of this application for several reasons. First of all, approval of this application and force pooling those remaining properties is going to facilitate a well being drilled just a few hundred feet from hundreds of homes belonging to City of Fruitland and Payette County residents. As was discussed earlier, it's just over the fence from one of our subdivisions. The main concerns we have, as far as the residents are, it's been discussed at length, especially during the drilling and flaring process, the noise that's produced, the light intrusion into neighboring properties. And we just have general concerns about the safety and welfare of our residents. Being this close, in the past, they've been fairly close to city limits, but not anything like this. This parcel or proposed parcel that's been identified for the well location is surrounded by 3 sides by city limits, by City of Fruitland. Only the northern portion of it is contiguous to unincorporated county. And so that kind of brings concern to us. Just south of that subdivision, there's a large mobile home park with, I don't know how many, I'm sure over 100 homes located there that would be, very close proximity also. And when it was discussed earlier about, the percentage or the number of parcels or the percentage of parcels that were voluntarily leased, I guess I would be curious to know at the time a proposed parcel for the well itself, as far as I know, to my knowledge, had not been identified. So I would really question all of the people that voluntarily leased in that subdivision and some of the neighboring properties, if they would have been so willing to lease, had they known it was going to be approximately 200 feet, 250 feet over the fence from them. And so, I mean, in the past, the city's received a lot of complaints. People don't understand where city limits are and what's in the unincorporated county. So in some of the previous drilling and flaring operations, we received a lot of complaint calls. I always direct them to the county and tell them that the county commissioners are who represents you, and any complaints you have about the noise and light intrusion needs to go to them. But with this one, for sure, we'll be getting a lot of calls because of that subdivision being so close in proximity to it. I realize that the drilling, the flaring is very temporary, 2 to 3 weeks. Sounds like it's kind of the typical amount. However, I know it does reference in the state code that, it mentions depriving people of being able to enjoy their private property. So, I mean, if you had somebody outside your bedroom window banging on a drum for 2 or 3 weeks, 24 hours a day, I think that is definitely depriving you of enjoying your property. And I know at a previous hearing at the county, I gave testimony and brought up the fact that, at least if something like this was permitted, that the drilling only be allowed during basically daytime hours. The producer, and I understand this, and I'm not debating it with them, but I understand that it's harder for them to do that. It's more expensive for them to do that. But I can't imagine that it's been said that it's impossible to do that. Well, if you're operating a drill rig and it breaks down and it's down for 12 hours for repairs and you fire it back up, that tells me that they can be shut down and restarted. So at least if something like this were to move forward, if that drilling was taking place during, some reasonable hours, I think that would make a lot of sense. The city also has some concerns with the use of city streets to access this parcel. That parcel, if you look on the far west end, there's a very narrow curb cut. The rest of the southern portion of that parcel is all vertical curb gutter and sidewalk. And so I don't think there's any way you're going to get a drilling rig in there without jumping that curb and sidewalk, and potentially that sidewalk's only 4-inch thick concrete. So there's potential for damage there. So we have concerns about, potential damage to our infrastructure and not having any kind of agreement to have the operator pay to repair any potential damage that might be done. And it certainly shouldn't be on the Fruitland taxpayers to pay for any damage that's done moving equipment in and out. I know they just mentioned that the county has concerns about this. They voted 2 out of the 3 commissioners. The majority voted that they wanted to incorporate a 500-foot setback from city limits to their gas and oil ordinance. I think that kind of sends a message that the county has some concerns about it too, as far as proximity. And to kind of summarize, I mean, I don't think this is a bad idea. I just think it's a terrible location for it. And so I know the 400-acre spacing unit is what it is. But the parcel that's now been identified to drill as well, it is just very incredibly close to residential areas. And so the mayor and council wanted me to share that, that we have concerns about that. It was mentioned earlier, I believe it was during Richard's testimony, they asked about having any meetings regarding traffic plans. He stated there were informal meetings, and I believe that must have been with Highway District 1. There's been no formal or informal meetings with the city of Fruitland regarding traffic plans, regarding maintenance agreements or repair agreements for damaged infrastructure. And it was also stated that, Highway District 1 said that 16th and then to use Highway 95. I don't know if there's been any discussion with ITD, but Highway 95 would be their jurisdiction as far as any traffic plans and approval of those plans. So I think that should be looked into also. But kind of to summarize, that's our concerns. I've stated before that the city of Fruitland, from conversations that the mayor and council have had, it's not that they're necessarily against gas and oil drilling in general. If it's a safe, adequate distance from residential areas, then that's one thing, but it's definitely caused concern with the proximity that we're looking at with this project and with this integration order. Basically, if it's approved, they've already identified that parcel, so that's the high probability that that's where it's going, and so we have some concerns about that. So with that, I thank you for your time.
Thank you. Yes.
Yes, I'm also a resident of Payette County out here. And I'd like to state that I'm a mother and a grandmother. And I would like to say that Payette Recreational District and their whole park is right there as well. Their tennis courts where the young kids play football, soccer, baseball, softball. And my worry is for these young children being out there during this time with these fumes when they're flaring, going up in the air. Because these children are our future. And that's what I care about, is my family and this town of Fruitland. I have lived here my whole life. My husband works with the football team. We care about our community. And I want to see that it continues to be a good community to live in. Thank you.
Thank you. Would you be willing to share your name with us, please?
My name's Brenda Ishida.
Thank you. Anyone else want to share any comments now? Yes, sir.
Yeah, my name's Mike Gomez. I live in Payette County. As the citizens here, we trust that you guys are going to do the best for us. It's my understanding that these folks who were involved with another company that has gone out of business. I did a little research, and there's a few complaints with their past work. So I don't think they should be allowed to come into our neighborhood and do that same kind of stuff again. Also, the spacing unit was allowed to be smaller than normal. Am I correct? And so that makes me concerned that maybe they wouldn't have been allowed, or they wouldn't have gotten the necessary 55% if they would have had to go with the full size spacing unit. So that's all I have to add.
Thank you.
I'd like to
Wow.
make one more comment.
Yes.
I don't know if the oil people are aware, we live on a fault. So we're very prone to earthquakes. We're on the San Andreas Fault.
Okay, thank you. Yes.
Yeah, can I just add one quick comment? We're talking about the emissions from these operations. The drilling on the wells, yeah, it can last just a couple of weeks or a couple of months, but they're constantly coming back and reworking those wells. It happens a lot. It's happened on all the other wells around here. There's a lot of heavy truck traffic. But the other danger from this being so close to these kids' playgrounds and schoolyards and high density subdivision right there a couple hundred feet away is, besides the flaring that does occur regularly, just the emissions that come off of these facilities. 2 years ago, we worked with a thermographer from Earth Justice and did some FLIR filming and found out that there are other facilities here owned by this company and the previous company were leaking like a sieve, putting toxic VOCs, carcinogenic materials into the air. That's why the setbacks are so critical. They say it's a good mile away before you're safe. And when EPA sent violation notices to Mr. Brown, he denied that they were his facilities, made a statement that he didn't think he could comment on something that wasn't his, which was absolutely not true. And I can send you that evidence too. So we don't trust these guys to, their bottom line is making money on this deal. We understand that. We understand that it's expensive for them to operate here. But sometimes it's just not worth the expense and it's not worth the risks. And this air pollution is a huge one. So I just wanted to reiterate.
Thank you. That one of those comments brings up a point. And Ms. Richter, let me ask you, does the Department of Lands have a position on when the public comment period ends on this application? Do you continue accepting those public comments? Would we be allowed to accept them and have them included in the record if, say, we allowed folks a week from today to continue doing that? Any objection from the Department of Lands on that?
No objection.
Thank you.
It's Christmas.
So what we will do, because I did hear at least one person suggest that she might want to submit some additional documentation in support of a comment. The public comment period will remain open for 1 week from today. I want to make sure that any of those comments that the parties may want to address in their filings, they have an opportunity to do so. So it'll close 1 week from today, but you can continue to submit public comments through the website at the Oil and Gas Commission. And those will be included in the record, and they will forward those to me as well.
Is that 12/27 at 5 p.m. or something? Is that the exact deadline?
12/24.
24.
Yeah.
Yes, I'm off, so.
Christmas Eve.
Thank you.
Well, we all want to be thinking about oil and gas leases.
Yeah, but
Yes.
thank you.
All right. Thank you. Any other comments that anyone wants to share? I want to thank everyone for their time today. I know most, if not all of you, sat through the entire proceedings. Appreciate you showing your interest in this and sharing your thoughts with us as well. And what we're going to do now is we're going to go into recess for the rest of the afternoon. We will come back shortly before 5 o'clock, and I will reopen the record for any additional public comments, because that's how we scheduled it with the notice. And I understand that some people weren't able to be here during these hours, and they have a reason to expect that we'll be there to listen to them at 5. So that'll conclude the proceedings for now, but we will be back shortly before 5 o'clock. We're back on the record for the public comment portion of the public hearing in the application of Snake River Oil and Gas LLC for an order integrating unleased mineral interest owners in the spacing unit consisting of the southeast quarter of section 15, the east 1/2 of the southwest quarter of section 15, and the northeast 1/4 of section 22, Township 8 North, Range 5 West, Payette County, Idaho. This is a proceeding before the Idaho Department of Lands. It's agency case number CC-2025-OGR-01-005. And its Office of Administrative Hearings case number 25-320-OG-04. I am the assigned hearing officer for this application. I am an administrative law judge with the Office of Administrative Hearings in the state of Idaho. My name is Scott Zanzig. Earlier today, we conducted an evidentiary hearing. At that hearing, the applicant, Snake River Oil and Gas, some objectors who live in the unit that's being affected, and the Department of Lands all had an opportunity to present testimony under oath, as well as some documentary evidence. In addition, in these public hearings, we provide a process for members of the public to comment as well on these applications. There were a number of people. Some of you were here for the hearing itself and may have made some remarks. We allowed some public comment earlier, but because we wanted to have this set for folks in advance so they knew when to show up, we're starting this one at 5 o'clock as well. We have an hour that the city of Fruitland has been kind enough to allow us this evening to use their space. And so what we'd like to do is offer the opportunity for folks who have something that they want to say about this particular application to be able to speak their mind freely here in our hearing. You will not be asked to take an oath and testify under oath. You will not be subject to cross-examination by any lawyers. You're just free to speak your piece. What would really help me in doing this is to just find out how many of you would like an opportunity to speak tonight? If you would just give me a show of hands, that'll help me know how much time to allot for folks to speak. So I see about 5 or 6 hands, so I think everyone should have an adequate opportunity to speak, and I don't think I need to hold you to any particular time frame. If we start running close on time, we may have to hold people to just, several minutes, but I think we have plenty of time for this. So what I'd like to do is ask folks, if you're going to speak, you're free to speak either from your seat, or you can come up to the podium. Some people are more comfortable doing one or the other. You're free to do it either way you'd like. When you get up to speak, would you please let us know your name and whether you live in this unit that's being affected by this application? And that would really help us understand the context of your comments. And then you're free to just tell us what it is you'd like us to hear about this application. So without further ado, folks, again, if you'd like to speak, if you'd raise your hand, and maybe we'll start on this side of the room and just go this way. Yes, ma'am. Would you like to speak?
My name is Julie Fugate, and yes, I live in section 15 here in Fruitland. I live in section 15, less than 1/2 mile from the proposed drill site. I did not sign a lease. I am angry that because of lies and deception by Snake River Oil and Gas, I'm being forced pooled or integrated. I want to take a moment and defend my neighbors that signed an oil and gas lease. The oil and gas company only received their percentage of signed leases because the landman knocking on doors lied and deceived my neighbors that signed. They were told this was free money. All your neighbors are signing. We are doing this anyway. You will get $500 like your Barlow neighbors. Sue Bixby lives in the Barlow section where they punched 3 holes less than 1/4 a mile from her front yard. I asked Ms. Bixby if I could share the money she received from the production of the 3 wells. She said, yes, I want folks to see how the oil and gas company misleads people. Please note, she did not sign an oil and gas lease that was integrated. I looked at her invoices over 55 months from May 2021 to the present. She received only 1 check for a $300 figure in February 2023. Only 1 check for a $200 figure, which was a month later, March 2023. Just 5 months later, her check dropped to $2.55. Keep in mind, this is with 3 wells producing. The landman does not share that the drill site will be in your front yard or your backyard, or any money received is very short term. He does not mention the extensive risk associated with being so close to a drill site. When Richard Brown, owner of Snake River Oil and Gas, was told in a public meeting the landman lied, Mr. Brown stated, we contract with those guys and we are not responsible for anything they say. So who is responsible for what the landmen say? Somebody needs to be. It is my understanding that Woodbrain is anxiously awaiting royalty checks. They need to know the checks will only be a few dollars and it's not worth the risk to them, their employees, and their neighbors. This projected drill site impacts the entire community, especially the city of Fruitland. The Rivercrest subdivision has 58 homes. The Desert Rose Mobile Park has 128 homes. These homes are just a few feet from the projected drill site. I understand the county just voted in a 500-foot setback. I talked with Mildred Sheffield at Payette County this morning. She said the ordinance includes a waiver, and she went on to explain the waiver can void the 500-foot setback. In January 2024, I presented information to the Payette County Commissioners. One article I shared stated if one is living within 1/2 mile from a drill site, there are health issues. The second article was a proposal in New Mexico for schools and daycare centers to be 1 mile from any drilling activity. Why are we not learning from states that have been involved with oil and gas industry for decades? In summary, this money is not free money, and it's not even $500 a month. I am angry that because of lies and deception by Snake River Oil and Gas, I am now forced pooled, and I am a witness and a victim to all of this. This application needs to be rejected. Snake River Oil and Gas needs to secure a location away from homes, schools, churches, businesses, in order to avoid impacting citizens with drilling and flaring and other long-term risks. Oil and gas drilling needs to occur away from communities, period. Thank you.
Thank you, Ms. Fugate.
Okay. Can I also have the articles that I referred to? Can I show them with you? I'll just give them to you. And then also, this person came this morning, but she wasn't gonna be here, so she asked me to give this to you. Is that okay if I give that to you?
It's okay if you give it to me.
Okay.
I will make sure that these documents get included in the record.
Okay, thank you so much. Appreciate it.
All right, so who would like to go next?
You go.
Yeah, yes, sir.
Good evening. Thank you for the opportunity to speak. So I'm Stuart Bright. I'm a resident of Payette County. Not in this particular integration area, but in another area where previously they had attempted to do an integration, if you will. So first of all, I'd like to echo Ms. Fugate's comments about the less than stellar behavior of the landmen and women who have been involved in this process over the years, where they do take liberties with the truth. And when they came to our house and said that our neighbors had already signed agreements with them, that we knew that was a false statement. So, again, I'll just echo her comments about their less than upstanding behavior. Furthermore, this decision that we have for this proposal, will set a precedent for future integration decisions here in, well, I guess across Idaho, but in particular here in Payette County. So I have concerns about my property and my family's livelihood. So first of all, we heard a lot of discussion this morning about royalties. That one of my frustrations in this whole process has been the way the state has set up these rules. And so maybe the first 55% of the acres can be for more than 12.5% royalty. But once they hit that threshold, the remaining 45% are locked in because the oil and gas company has absolutely no incentive because of the state rules to do anything more than 12.5%. So I think that is unfair. I don't know the right words for it here, but I don't think it's a good situation. The state is supposed to be looking out for the residents' best interests. I do not think they have our best fiduciary interests at heart there. Furthermore, those standards, that 12.5% was set several years ago when these rules first came out, but haven't been updated. And currently, throughout the US, the royalty rates for oil and gas is like 16 to 20 to 25%. So we're sitting at 25 to 50% below what the rest of the nation is getting. So I think, again, we're not getting a fair economic return if this decision to drill here in Fruitland goes forward. And I think that is irresponsible, again, on the state's part to set us up for that kind of economic loss. And we heard discussion from Mr. Moore this morning about how expensive it is for this particular operation because of where it's situated, that I don't think we or the people in that integration area should be subsidizing Snake River's decision to drill a very expensive well. And I think, again, the people in that area need to deserve to have a fair economic return for their minerals. And beyond the economics, I am really hoping that you'll reject this proposal because of the location. So the area is the field, or the proposed area for the well itself is a field that sits on county land, but is surrounded immediately by the high density residential areas that were already mentioned. Within the boundaries of the area is the largest park, Mesa Park, and then it's also an industrial area with wood grain right across the road. There are businesses on the west side, and one of the busiest, if not the busiest intersection in the whole county. So there's a huge amount of traffic that goes right by this location. And I'm really, again, somewhat dismayed at how the state has set up these rules. And Snake River Oil and Gas has no incentive to go beyond the minimum requirements that the state has. But I would ask, if you decide to go forward with this decision, you know, it's right in a very significant area, you know, it's less than a half a mile to the river, which then drains immediately into the water treatment plant for Fruitland. So I really would hope or demand that there are additional requirements. You know, there's language in the state rules that it is recommended for the oil and gas companies to have a discussion with local emergency responders. I think that has to be a requirement, that they come up with a plan with the county, city, and relevant state agencies to have a response, because having grown up in Louisiana, Alabama, I know that oil and gas wells are not immune from accidents happening. So I don't want to see that happen here. And beyond just requiring that they have those emergency response plans, there's also the issue about the minimal bonding requirements that the state has. It's like $10,000 basically for a well. And it's like, what are you going to do with a $10,000 bond when that well goes out of production? And how do you ensure that it doesn't become a future hazard and liability for the residents here? So those are some of my concerns. So thank you.
Thank you for sharing. I know I saw some other hands. Is there someone else who'd like to speak? Yes, ma'am.
My name is Shannon Crawford, and I do live in the integrated area. I did not sign a lease. My name is Shannon Crawford, and I reside in Fruitland and live less than 500 yards from the proposed project of the boring hydraulic fracturing or fracking. You can research the dangers to you, your family, and our town's health when exposed to natural gas drilling sites, the leaks, the pollution they cause, and the list of short-term and long-term effects is awful. My additional concerns are, as a small business owner, the noise and light pollution from the drilling location happening 24 hours a day at less than 500 yards away from my home and business will create disruption to myself, family, neighborhood, and my clients. Safety. Earlier today, Mr. Brown with Snake River Oil and Gas stated his company was bonded, but he could not give an amount. This creates greater concern if there was a catastrophic explosion, which could happen. Who would be responsible for recourse then? Traffic patterns, the busiest intersection in Fruitland at Highway 95 and Northwest 16th, accommodating over 7,000 automobiles and large trucks per day, is less than 500 yards from this proposed natural gas boring site. At this morning's hearing, witnesses provided no proposed solution for the traffic that will be impacted on Northwest 16th Street. And as a homeowner in Rivercrest that has one entrance and exit, if there is a natural gas emergency, this creates an additional hazard to my neighbors and myself. This project is within city limits on 3 sides. This project is proposed in the wrong location. A project like this does not belong in our city, right next to high-density neighborhoods and busy intersections. It is not good for our neighbors, our town, and our families. Thank you.
Thank you. Sir, I saw your hand.
I'll just stay right here if that's okay.
That's fine.
I'm an ex-school teacher, so I wander around a little bit. So.
Could you share your name with us? And where you live in?
My name is Mel Person. I live at 2146 Northeast 16th Street. And we are not in section 16. I believe is what it is. We are in another section. And we're gonna go back a few years and we were where some of you are now dealing with gas and oil. So I was curious, like, I heard so many things when we were going through this process that some of you are going through now. So I decided I would call Richard Brown. I believe that's his name. No, it's Brown. Okay. And asked him if he would meet me at a coffee shop or a restaurant or whatever. And he said, sure. So we met in Payette. And he brought his nephew with him, and I can't remember his name, but anyway, so we talked for a little while, and so I'm just here to get some information because I'm hearing all kinds of things and I want to get it from the horse's mouth, so to speak. So we talked for a while, and then his nephew was in charge of drilling wells. So he started the conversation by saying, just so you know, and this is the quote, just so you know, the way we drill a well, there is a 0% chance that anything bad can happen. I said, wait a minute. I mean, I was born at night, but it wasn't last night. So that can't be right. So Mr. Brown jumped in and said, well, no, that's not right. There is a minimal, chance something bad could happen. And so he went on and kind of explained it, but it told me that they'll tell you anything to get you on board. And they both knew that was a lie, but they, told it anyway. But nothing bad can happen. Well, we all know that's not true. So another thing that we've learned is that while they're drilling the well, there's an awful lot of noise. I mean, the wells that are on Barlow's property are quite a ways from us, but we had to sleep with the windows shut because that well drilling that was going on was very, very noisy. And so you better get used to that idea. And of course, at some point they're going to be done drilling a well, but then they have equipment down there, not necessarily noisy, but the drilling process is very noisy. I was told today that they were talking about putting hay bales up around the dairy where they're going to drill to try to minimize the noise. Well, they better get a whole bunch of those hay bales or straw bales or whatever, because they're definitely going to need them. We were told all kinds of things about what kind of royalties, what our share is going to be, what we're going to make. And we never did sign a lease. We were force pooled, so we didn't sign, but we do get gas and oil money. One time we got $500. Now, why we got that much, I don't know. It's been a year or two ago that happened. My wife, Terry, and I were just talking about what do you think the average would be? 20, 25, 30 maybe. The last check we got was for $5.60 or something like that. That's the last one we've seen. And so it's not worth it. I mean, it's just not. There are places suitable for gas and oil, and we do need that. We all know that. I mean, it drives a lot of our economy, but man, we didn't think that where we lived was a good place, even though that well is clear down by the river. But that was some more kind of negatives too. You're getting close to water, a major river that runs right through here where a lot of our water comes from. But we just it's just not worth the chance that something bad could happen. And if it does, who's going to pay for that? How does that work? And so a lot of people are being put at risk, and we just felt like we fought it, but we didn't win. And now you're just stuck with, whatever happens. So anyway, like I said, there are places suitable for wells, but man, that section's not it. It's just not, so. Thank you.
Thank you, sir. Is there anyone else who would like to speak? Yes, sir.
I'm John Sandquist. And I have some property that butts up to a corner of the property here in
It's turned on.
Pennsylvania. We haven't signed a lease. And my opposition goes back really quite a long ways. And I'll just relate a couple of instances why I've been opposed to it for so long. Several years ago, when the things were just getting started with the drilling and the fracking around here, our oldest boy is a PA, and he went back to he had a workshop back to Pennsylvania, the University of Pennsylvania, and he called me. He was back there. One of the people that he met, one of the guys that he met from Pennsylvania, told Kemp that he said when they were talking about the fracking or the drilling that was getting started, and he said, well, he said, tell your dad not to get involved in that. And then he said the reason was because where his parents lived in Pennsylvania, they lived out of the city on some property, and I don't know if they were forced food or not, but anyway, they came on their property and did their drilling operation, and within a very short time, their water was contaminated. They experienced tremors and some health problems, and so they just had to leave. Their property was essentially worthless. And he said that was the place that he was going to have his forever home on his parents' property. So, and we've also experienced the fact that we were told, well, you know, we have enough signatures. And I always ask, well, why do you need mine? And I never got a good answer. And so then here just a few years ago, you know, we've had a lot of people come and offer to get our mineral rights, but one young fellow came by and asked if he could come in and talk for a little while. He didn't say why. He had a clipboard with him, and I pretty well knew what he was going to talk about. So I said, come on in, we'll talk about it. So when he started talking about the mineral rights, I said, well, I'll stop you because, and then explain to him why we were opposed to that. And he told me, he said, well, I understand that. And he said, I can tell you this now because I'm quitting my job. And he told me he was from Alabama or Arkansas, one of the two, I can't remember. But some people that were familiar with, or were friends of his family, they were integrated, and they were adamantly opposed to anybody coming on their property. And it got to the point where the sheriff had to come out and be there or take them while they were on their property. And he said, I've seen too many things that just weren't suitable for me. And he said, I'm quitting my job, I'm going back to school. And I said, I think that's a good choice, and wished him luck. And so just like we've heard comments tonight about, seems like there are instances where there's not a real close relationship with the truth. And you know, I'm an old man and kind of from the old school, I guess, but when you make a deal or an agreement or a contract with somebody, it's in the spirit of trust, and there's a lot of integrity and honesty involved. And I think we see situations now a lot these days where that's really not the case. So that's why I'm opposed to it.
Thank you for sharing. Yes, sir.
So I gave testimony this morning on behalf of the city. Can I add a little bit to that? Is that?
Yes, you may.
Can I approach our map there?
You may.
Oh, good. So I just wanted to, oh, sorry, Don.
No problem.
Just wanted to point out, because I forgot to mention it this morning. So the proposed drill site is right here on the Mary Ann Miller Trust property. Our comprehensive plan has all of this up here zoned as single family residential. So as that property comes into the city, the plan has always been that it will be developed into single family residential subdivisions, much like the existing one here. And so I kind of concluded this morning's testimony with, you know, it's not a bad idea. It's just a horrible location for it. And I wanted to point that out, that with this being surrounded by more single family subdivisions, that kind of makes it even more clear that it's just not really an appropriate place. And I know this is just the hearing for the integration to force pool the uncommitted owners, not the actual drilling permit hearing. But you know, if you look at a map of our city and you look at the geographic center of our city, which is basically Gateway Junction, we just think that planting a well right there is a very, very bad idea because of the proximity to existing residential areas with a lot of homes there, and what in the future will have several hundred more homes coming up. So just wanted to bring that to your attention.
Thank you, sir. Just for our record, could you just state your name again?
Sure, Stuart Grimes. I'm the city administrator.
Thank you.
You bet. Is that what you were gonna ask? Yes. Okay, sorry.
I see another hand here. Yes.
I'm Shauna Pearson. I live in Fruitland city limits, and we're not, I think we're the next unit over. I guess how that goes. We did not sign the lease. We didn't go down that road. But I will tell you that the man that came to our house and tried to sell it to us, he was there continuously. And finally, I just quit answering the door. And they would tell you one thing, and then you come back the next week, and then he'd tell you something different. I just, the quality of the person that was doing, I guess, the selling was not good. It was very unethical. You know, we're a really small community here, and I could see where a big gas company, oil company could come in and think that they're just gonna run over Fruitland. And that's not right. It's not right that we, you know, we work hard here. We have families that have had businesses and their homes here for years. We shouldn't be just run over. If you look at that map and all the homes, brand new homes that have gone in around that, it's embarrassing to think that anybody of any quality from a gas or oil company could come in and say, oh, that's a good place. Oh, right next to Gateway Junction, all those cars and trucks, and how do you, oh, that's a good place. It's not. It's not good at all. And then for people to come into us, my husband, he's on the city council, and I have not gotten involved in this because I thought, surely this is gonna go away. You know, because I was embarrassed what they were doing to us. And my husband would come home, he's like, you're not gonna believe it. And our county court, they kind of sold out too. It's awful. It is just awful in this day and age, and all the damn land out there that you can't find someplace better than in our impact area. Would you want a well 300 feet from your house? Do you have property? Maybe we could do something like that. We just move it. And I don't care if it goes out in the county away from our water source and away from all these people. There's property out there that this is embarrassing. And I'm really glad I booted that guy out of my house because he just kept lying about stuff. Anytime, you know, you try to, oh yeah, all your neighbors have signed. No, they did not. None of them had signed. But I think they're like, oh, here, dumb white gal, she'll sign.
Yeah.
No. Let me see. I think there was one other thing I was disgusted with. You know what? A lot of it just goes back to integrity. Just integrity and the way that people choose not to use it anymore. Pretty uncommon, I guess. Thank you.
Thank you. Yes, sir.
I just meant, I forgot to add, you know, I'm not opposed to that, but this location, just, like she said, Shauna said, it's just wrong. I mean, situation like that there with all the potential for problems, it makes no sense.
Thank you, sir. Yes.
Could you identify?
Yes. Could you identify yourself again, sir, just so that we have the record of who spoke? Yes.
John Sandquist.
Thank you, Mr. Sandquist. Yes, sir.
I got a couple things I'd like to say. I'm Duke Fugate, I'm Julie's husband, and we live a few hundred yards from where that proposed site is gonna be. And we have a very good well, and it's about 50 feet deep. And they've got a proposed drilling site that's gonna poke a hole right through our water aquifer. And all of the chemicals and the poisonous materials that they pull out of the ground, if they happen to spill any of that in our water aquifer, and we have about 20 people down there that has their own private wells, we don't have city water, we have no way to get city water. And if they contaminate our water aquifer, it's contaminated for hundreds of years. It may never come back. So if our well's contaminated, we would have no choice other than probably just abandon our house and move, because or haul water in 5-gallon jugs or whatever to drink, because some of the hazardous materials that they pull out of the ground down below is it'll kill you. I mean, just pure and simple. And I've drilled wells. I've drilled a lot of water wells in my past. I know what wells do. I know what can happen. And if they drill and some of that contamination happens to get around their pipe and get down in, because they have to go right through our water aquifer. I mean, they're going to poke a hole straight down through our water aquifer is probably from 200 feet to the surface. It'll be 50 to 250 feet deep. They go right through the middle of that. And whenever they're doing that, they don't care what they're spilling, or they say they do, but then they'll say, well, we'll protect it with cement. But maybe they can make it work, maybe they can't make it work. But I have seen water wells contaminated before, and once they're contaminated, they're done. The whole aquifer of the people that live in our area will have to do something totally different. Our well right now is very good, and we want to keep it that way. So if they don't have to drill there, they don't have to drill there. They can drill 7, 8, 9 miles away and still come under the same place that they want to go. It's just cheaper. They want to do it cheap, and they'll go right through our water aquifer, but they could go 7, 8 miles over on a hillside out in the boondocks somewhere and still come and still retrieve the same amount of natural gas that they hit the same pool and from way far away, from out of town. And so I would recommend them doing that. They can go and drill a well right here and go 9 miles this way or 9 miles that way, and still, instead of drilling in the middle of town, go out of town and then come under. It's all about dollars to them. They don't care about my water. They care about dollars. And that's pure and simple. That's the way it is. That's all I got to say. Thank you.
Thank you for sharing.
Right.
We still have a little bit of time before 6 o'clock. Is there anyone else who wants to speak?
Yeah, I'm Shelley Brock. I'm the president of Citizens Allied for Integrity and Accountability of Kaya. I spoke this morning, but if you don't mind, I'd like to just add a few things based on what I've heard here tonight. First, Mr. Grimes, when he pointed that out on the map over there, that was really good, because in other states, Colorado, namely a few years ago, houses have exploded because they built housing areas over the top of where gathering pipelines had been put underground decades before and wells abandoned. And those things present a danger for forever, like they aren't safe once you move out of there. And if that stuff is, you know, slated for development eventually of housing developments, that's a real concern. Also this morning, I spoke about Richard Brown stating publicly that they can't directionally drill here. He said that the geology doesn't support it, even though, as a couple of us said, they've already done the exact same thing in the Fallon and the Barlow wells, which are in the exact same geology. So that was dishonest on his part. But I forgot to mention that the reason I brought up directional drilling is because it will allow them to exploit larger setbacks. They can drill from far away. I don't know if they can go as far as Duke just mentioned right now without, you know, it turning into something else, but they can certainly go. They've gone almost 2,000 feet, roughly 2,000 feet on other applications in the past, other wells that they've drilled. So that is definitely something they could do. And I don't know why he's, you know, said what he did. Also, someone mentioned fracking. I just want to say that even, and we asked this morning that you know, order that they not allow fracking on this well. One thing that I learned in 10 years of doing this on behalf of Payette is that conventional drilling really presents all the same risks pretty much as fracking. And in fact, they have acidized wells here, did it illegally with no permits, got caught for it later. We publicized that. They have not followed the rules and the laws that were in place very well. And just like these emissions coming from their infrastructure that EPA had violated them on 8 years before and nothing had been done about it. To my knowledge, according to the website, there's still nothing has been done about it. We don't know. The transparency that Mr. Brown mentioned is maybe he thinks he's being transparent, but those of us who've been dealing with this for a number of years, it's been a dog and pony show. There hasn't been a lot of transparency. There hasn't been a lot of honesty on the part of the companies. Let's see, just wanted to say a couple more things. And we are not opposed to oil and gas. If you look at the records of people from this industry that like to claim that Kaya is just anti-oil and gas, we never protested the wells that have been drilled out in the foothill region here. We didn't start making noise and talking to people and educating people about the risks until they moved right into town and right onto our rivers. They've drilled wells right in the floodplain of the river. They've done it around all these homes. They're trying to do it again in what is really the most outrageous application they've ever filed. We hope that you'll just, you know, say no on this application, but if not, at least give us the same, you know, give them the same orders that we got on a number of other applications in the past that provide some protections to the constitutional rights, the property values, the health of these families that are going to be living near this well. It's really critical. And I just have if no one else has to speak right now, interrupt me if you do. This is an op-ed I wrote 3 years ago, and I won't go into the whole thing, but I just want to say that citizens are paying dearly for this out-of-state Arkansas-based company, corporation, and a few wealthy large landowners. Those are the ones that are going to benefit from this. None of these people living on these little quarter-acre lots are going to benefit, including public officials with personal investments in the business. There are a number of those, from the highest office on down in this state to benefit financially. What other industry would be allowed to operate here in fiscally conservative Idaho while draining taxpayers of millions of dollars? What's in it for us? And this has been over the years we've been working. We've seen multiple lawsuits by homeowners forced to allow drilling under their property, including 2 by our organization, and another class action suit by angry landowners who alleged that they were being cheated out of their royalties a few years ago. And these landowners all willingly signed leases and then filed a class action suit. When Alta Mesa, who is Richard Brown's operating partner, went bankrupt, the suit dissolved. They never had any resolution on all the money that they probably lost. We know countless complaints of bullying by the landman have been filed by people over the years, and a number of you spoke about that tonight. And seismic crews, which cause a lot of problems in residential areas. Conflicts of interest between the industry and regulators, illegal lobbying, which has happened. unpermitted drilling procedures and pumping of toxic chemicals underground, including the acidizing of that well, as I mentioned. The officials, including one of your representatives here in Payette County, admitted publicly that they had allowed the industry to write their own laws and rules for years and that they regretted that. It's like the fox doesn't just guard the hen house, he's been allowed to build it. In my closing statement, corporate profits and government overreach should never supersede the sanctity of our constitutional freedoms or the preservation of our property rights, our irreplaceable water resources, and a right to be safe and secure in our greatest lifetime investment, which is our homes. Idaho's future should never be for sale. Mr. Brown this morning spoke about how it cost him $3 million to drill a well and complete it. Well, how much money does he think all of us have invested in what is our biggest lifetime investment, our homes, our children, their schools? It's ludicrous for him to, say what he did today and not also consider the other side of it. So thank you for letting me speak.
Thank you. Is there anyone else who didn't get a chance to speak yet?
I am in a section where they drilled. And when they drilled, it said, oh, we'll drill, there'll be no waste on the ground, there'll be no problem. We'll haul off of the waste that comes out and it won't be any problem. Now they want to drill a well to put all the waste back in the ground. And in the meantime, they say, well, we got these wells, we got all this gas coming out. What are we going to do with it? Can't put it in our hip pocket and take it down. So we got to hook it onto some upstream pipeline, transportation pipeline. And how did they do it? They went down underneath the river, back out, back down underneath the river. And what happens if there's gas leak under that river? I work for a gas company. I know what it's like when you have a leak. And I never worked for one that ran under a damn river. When there are residents all around that depend on the water source to maintain their life and their cattle and everything. Those are things that worry me. They're going to drill this well. They're going to transport it underneath subdivisions to get it out where they can go down underneath the river, back out, back down underneath the river. They're not putting that in contents to these people when they're saying, oh, you're going to make all this money. Well, number one, they come to my door and said, yeah, you're going to make this and that. We said, we're not interested. Guess what? It doesn't matter. You don't own anything. You just pay taxes on everything. And I don't think that's right. Oh, I know it's a percentage. But no, the people get a voice. They should be respected. Like Shelley said, you work your whole life for a home, for a future. What happens? Somebody comes along and they want to make money. They don't care what it's going to cost you. And I don't think we, as homeowners or property owners, should have to sacrifice our life dreams to make somebody out of state very wealthy. And what I look at of my paperwork that I get from the gas company, and they produced $100,000, but it cost them $92,000 to do that. But we're going to divide that amongst the 540 acres. What is that, peanut? It costs them more to send me a check for their paper, their postage, their ink, and their time than I get. And I think that's something they should be upfront with these people. They come to your door and say, oh, you're going to make all this money, we're going to make you rich. No, be honest with them. And that's what I have experienced with what's been going on, is there hasn't been a lot of honesty.
Thank you, ma'am. Could you tell us your name, please?
My name is Sue Bixby. I live at 2133 Maple Court, Fruitland.
Thank you. So am I correct in understanding that you don't live in the area that is this unit that's being talked about? But you
I live in the section adjoining it that they've already drilled in.
Thank you. And thank you for sharing that. We still have just a few minutes left. Is there anyone who didn't get a chance to speak who would like to say something before we conclude?
Can I say one more thing?
Yes.
Shauna Pearson, sorry. I know one of the things that this wonderful company had sold even to the city council was, we'll never build in your city. We'll never, no, we'll be way out. And I remember the guy that came to my house kept saying, I said, well, what's gonna keep you from putting a well right here behind my house? Oh, we don't go that close to residential. We have no reason. You got all this property out here. We'll go out there. We'll never go close to your house. I'll tell you what, those people right there are gonna be screwed. It's a bad deal. It's a bad deal.
Thank you. Did you have a little more that you wanted to add? No? Okay. Well, I want to thank everybody for their time this evening and for their interest in this project and this application, and being willing to share with us your thoughts that are very important, and they will all be part of the record of this case, and they'll be considered. What I want to let you all know so that you understand what happens now in this process, if you weren't here earlier today when I explained this. What happens now is the parties who were presenting evidence today, the applicant, the objectors who live in the unit, who filed objections, and the Department of Lands, they all have an opportunity now to present to me their final closing arguments in writing and their proposed findings and conclusions that they would want me to put in a recommended order. And they'll be doing that by December 31st. Once those materials are filed, they will be posted on the live docket that's on the Oil and Gas Commission's website. So folks who are interested enough and want to go there and see that, you're welcome to go and look, and you'll be able to see everything that gets filed. Once that happens, the administrator of the commission is required to issue a final order within 30 days. My job, what I'm supposed to do, is consider all the evidence I heard, all the public comments I heard, provide a written recommended order to the administrator enough time in advance before that 30-day deadline so that the administrator can look at what I thought, is free to either adopt some or all the things I thought, reject them if they think it's not based on the record. So I will be providing that. And that also, when I provide that to the administrator and to all the parties, that also will get posted on that live docket. So if you want to follow what's going to be happening over the next 6 weeks or so, you are all welcome to visit that site and to see what the various parties are saying about this application, what I think about it once I get to decide my recommended order, and then finally what the administrator ultimately decides with the final order. So that information will all be available to the public. And I know that it's important to the Department of Lands that this process be transparent, so at least things are happening out where people can see what everyone is saying, and whether you agree or disagree with various positions, it's out there for you to see and to be involved. So thank you for taking the time to be involved, citizens. This is a very important part of the process. I really appreciate your participation. That will conclude our public comment, and that will conclude our public hearing for today.